ઉદત રિપોર્ટ સેમ છે સાહેબ બધામાં ચારે ચાર મેટરમાં સેમ ઓર્ડર ઓબ્લેક રિપોર્ટ આવે એમાં છે ગુસ્સી લાગેલી છે પ્લસ લાગેલી છે ક્યારે રાખી હાલો બધી નંબરમાં શું છે એ મેઇન એક્સેસ છે રામોલ કાલ બધા મુદત રિપોર્ટ છે 8 નંબર ચલાવવાનું જવાબ આવી ગયો
આરોપીને 16 ઓફેન્સ છે, ગુસ્સી ટોપનો આરોપી છે. નામદાર ગુજરાત હાઈકોર્ટે 5 દિવસના પેરોલ મંજૂર કરેલા. રેગ્યુલર 35 દિવસ ઠરાવ્યા. પીરિયડ રેગ્યુલરાઇઝ કરી દીધો છે. રેગ્યુલર બેલ મૂકેલી બહુ મૂકેલા. That is exhibit 15. Thank you. Thank you. The table, the start of page 90, the table at the top. The serial number page 7. The serial number है बिलास पे दूसरा है बिलास. Champion Agro Limited, Federation of Proceeds of Crime, by allowing transfer of bank loan contract to a tune of ₹5 crore in a savings account. Vilas Bay Jitendra Kumar Hirapara further assisted the director of Mrs. Champion Agro Limited to launder ₹20 lakh out of the ₹1.2 crore, for which he opened demat account in her name, where the proceeds of crime to the tune of ₹20 lakh were deposited in the form of shares of Mrs. Champion Agro Finsec Limited. Thus, Vilasben Jitendra Kumar Hirapara is actually involved in the activities connected with acquisition, possession, layering, and use of proceeds of crime to the extent of ₹1.2 crore, and therefore is guilty of offence of money laundering. Now, my lords may turn to page 25 of the complaint. So your role is to the effect that 1.2 crores were transferred to your account. Out of the 20 lakh you have invested in some demat account. Yes, sir. The allegation is that 1.2 crore from the company's account was sent to the account of this Miss Vilasben. Out of that, 20 lakh is deposited by Vilasben in her name in demat account is the allegation. The remaining 1 crore is transferred to her husband and the other main accused, Mr. Dheeraj Hirapara, and then they have subsequently transferred that for investment. My lords, with respect to these facts, they are stated as page 28 of the complaint. My lords, my para 8.3.4. Page number? Page number 28. Yes. My lord, I may read from 8.3.4a, my lords. The 8.3.4 is facts related to diversion of ₹1.2 crore from CC account so and so maintained in IDBI Bank Limited used in purchase of shares. The accused claimed that ₹1.2 crore from CC account number so and so of Mrs. Champion Agro Limited maintained in IDBI Bank Limited was transferred to the savings account of number so and so of Vilasben Jitendra Kumar Hirapara on 21 June 2012 for the payment against the agricultural produce, mainly gram, wheat, and groundnut supplied by her to Mrs. Champion Agro Limited. Now, this, my lords, may find that my lords, the annexures to the complaint, annexure F is the statement of Dheeraj Lal Hirapara in his statement before the authority. at page 193, question 4. Annexure F, page 193. What is that? My lord, I may read. It is the statement of Mr. Dheeraj Lal Hirapara, who is an accused. My lord, the question number 4 at page 193. I may read it, my lord. Question number 4. Please furnish the reason for transferring of rupees 1.2 crore to Srimati Vilasben Jitendra Kumar Hirpara on 21/6/2012 from the loan bank account number so and so of Mrs. Champion Agro Limited, maintained in IDBI Bank. But I may read the answer. Yes. And the answer is, I state that Mrs. Champion Agro Limited transferred rupees 1.2 crore to Srimati Vilasben Jitendra Kumar Hirpara on so and so from the loan bank account of so and so Mrs. Champion Agro Limited, maintained in IDBI Bank, for the payment against the agricultural produce, mainly gram, wheat, and groundnut supplied by her to Mrs. Champion Agro Limited. Yes. My lord, the allegation against her is that એમને કંપનીના અકાઉન્ટમાંથી 1.2 crore rupees ટ્રાન્સફર કરી આપ્યા હતા અને એ અકાઉન્ટ એ પૈસાથી એમને શેર્સ લીધા on the same day. That is the allegation, and therefore they are saying that there is money laundering. My answer to that allegation is that money which I have received, it's towards all of these groundnut, wheat, and gram supplied by me to the company, because the nature of the business was such that Champion Agro had their own 50 or 52 stores throughout Gujarat. They were called warehouses or stores. Now, they used to supply agricultural products also to the farmers, such as machines or seeds or pesticides or other small things which are required for necessary to produce the farm products. And they used to also purchase the same from the farmers. Vilasben also consistently has stated that she used to continuously supply the same to the company, and in lieu of that, company used to pay her. There is agricultural land also in the name of Vilasben, which is also borne out from the ECIR itself. So this has not been considered by the authority. Now, my lords, this PMLA complaint was filed in 2024. The original NPA happened in 2012. In the interim 12 years that passed, business was shut. In 2020, CBI has already confiscated all documents and everything available with me. After 12 years, they say that you are not able to produce any documents. So therefore, we cannot believe your stand. But this was when after my stores are shut, because the recovery proceedings were going on by the banks, I did not have physical access to my stores altogether, which had all the data and records. Whatever I had was already confiscated by CBI. Yes. Secondly, my lords, the accused number 7 is not even a graduate. As such, my argument would be that for Section 3 of the PMLA, as per the judgments of Honorable Gujarat High Court, mens rea is an important factor in determining whether the accused was actually involved in money laundering or is actually liable under Section 3 of the PMLA Act or not. Now, my lords, as such, accused number 7 is not even a graduate. Her consistent stand, even in her statement, has been that I was neither aware of the transactions happening in the company, nor was I involved in day-to-day affairs of the company. She was only signing on documents which were given to her by her husband, who is Jitendra Kumar Hirpara. He is the brother of Dheeraj Hirapara, and both of them are the primary people who were running the entire business. Even their statements, they say that we were managing the day-to-day affairs of the company, and they are responsible for the day-to-day affairs of the company. Therefore, as such, accused number 7, her only role as she is the housewife of one of the primary accused. There is absolutely no document or evidence on record to show, which has been produced by the prosecution, that she was actually aware that shares are bought in her name, or the fact that there is a demat account opened in her name. એના સ્ટેટમેન્ટમાં તો એટલું જ કહે છે કે મને તો કાગળિયા પર સહી કરવા આપે, હું બધે કાગળિયા પર સહી કરીને આપતી હતી. પછી આગળ કઈ રીતના કરે છે, શું કરે છે, મને ખ્યાલ નહોતો.
And this is, my lord, something which is a very common practice, that generally when gents are running or males are running, the husband is running the affairs in the household, accounts are opened in wife's name, and generally they may not ask so many questions or go into details. But that would not make them fall in the ambit of Section 3 of the PMLA Act. And more so, because they have taken statements in respect of other allegations or other accused persons also. આ સાહેબ જે બીજી કંપની છે ચેમ્પિયન ફિનસેક ને ચેમ્પિયન ફાઇનાન્સ, એમાં there were 4-5 other directors. Now, as such, if their culpability is to be done basis only the possession, or even if you are aware of all of this, if you are only in possession of the proceeds of crime, then as such everyone ought to have been made an accused. But the prosecution has only cherry-picked people they want and made them as accused in this PMLA complaint. And that, my lords, I will show later on in one of the other accused, which is Mr. Tarpara, Kantilal Tarpara, my lords. So for accused number 7, my lords, my argument would be that there is no mens rea. She was never aware of the fact that all of this is happening. In her statement, she says કે મને તો જે કાગળિયા પર સહી કરવા આપતા હતા. And the primary accused have said that અમે જે એમને પૈસા લીધા છે કંપની પાસે, જે ટ્રાન્સફર કર્યા છે, that is towards supply of produce that she has supplied to the company. And it is her money which has later on been invested. The mere fact that it has happened on the same day is nothing to say that there is any criminal activity involved.
So number 7 is
My lord, only 2 judgments of the High Court on mens rea I would like to rely upon.
pertaining to the PMLA.
Yes, my lord, then under Section 3 of the Act. One is, my lords, Jafar Mohammed Hasna Fatta versus Deputy Director. My lords, may I go to para 40 of this judgment at page 36.
Yes.
My lords, may I read from C actually involved at page 36?
This is the definition of PMLA. Page 36.
36, my lords. 36 of 52 જે નીચે લખ્યું છે ને.
Yes.
My lords, from actually involved. Actually involved, my lords, this is in the context of Section 3 of the PMLA Act. I may also read, my lord, Section 3 once.
You can skip that section.
Very well, my lord. Actually involved. Actually involved would mean actually involved into any process or activity connected with the proceeds of crime, and thus scheduled offense, including its concealment, possession, acquisition, or use. There is absolutely no material or circumstantial evidence whatsoever, oral or documentary, to substantiate any such allegation qua the petitioners. Neither any of the petitioners is arraigned as accused in the scheduled offenses punishable under IPC for direct or indirect involvement, abatement, conspiracy, or common intention, nor is any such case made out even on prima facie basis against any of them. The second of the 2 prerequisites to attract Section 3 of PMLA would be satisfied only if the person also projects or claims proceeds of crime as untainted property. For making such claim or to project proceeds of crime as untainted, my lord, may now mark this. The knowledge of tainted nature, that is the property being proceeds of crime derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offense, would be utmost necessary, which however is lacking in the instant case. Great emphasis was laid on behalf of respondent on Section 24 of PMLA, which the prosecution, even in the present case, in the reply to the discharge application, has relied upon, which reads after amendment by so and so as under. Then, my lords, may I read para 41. On the basis of the said Section 24 read with Section 3 of PMLA, it was contended on behalf of the respondent that knowledge of the scheduled offense or proceeds of crime is not essential under Section 3, and mere assistance in handling proceeds of crime, even without knowledge, would attract offense of money laundering, and burden would shift on the accused to prove that he is not involved in money laundering. It was submitted that the petitioners are all adults having knowledge of right and wrong. The bank accounts in which they received payments and made further payments were all in their names, and they were signatories having power to operate the accounts. None of them had the slightest hesitation in allowing their account to be used as a transit point for further transfer of proceeds of crime. It shall thus be presumed that they have thus knowingly allowed the use of their bank accounts and knowingly involved themselves in this activity, having full knowledge of the purpose and intent of the transactions and helped in the process of layering. Thereby, they are involved in the process of money laundering. My lords, this was in the context of betting on cricket games. And that's para 42, my lord. Now, I find no merit in this stand of the respondent. I am of the view that this amended section 24 shows legislative intent of attachment and confiscation of proceeds of crime by presuming involvement of proceeds of crime in money laundering, irrespective of whether the person concerned is or not charged with the offense of money laundering. Thus, there shall be a legal presumption in any proceeding relating to proceeds of crime under PMLA that such proceeds of crime are involved in money laundering. Burden would be on the person concerned to show to the contrary. However, as rightly pointed out by the learned senior counsel for the petitioners, there is no legal presumption in this section 24 that A, the concerned properties proceeds of crime, B, the person accused has knowledge that property is proceeds of crime, and C, the person is involved in or is guilty of money laundering merely for possessing or having any concern with the proceeds of crime. In fact, this section 24 clearly indicates that even a person in possession or connected with any proceeds of crime may or may not be charged with the offense of money laundering, which is what they have done. They have cherry-picked accused in this case. Whether a person shall be charged with money laundering or not shall thus depend only upon satisfying the requirements of Section 3 of PMLA, as already explained above. Now, my lords, may go to para 52 at page 46. In the instant case, there is absolutely no evidence against any of the petitioners to have any occasion to turn to the confession of co-accused in order to receive assurance to the conclusion of guilt. Therefore, trial on such statement of co-accused collected subsequent to cognizance would be futile and abuse of process of law. In the material before the special court for PMLA, none of the statements of any witnesses even remotely referred to the petitioners. None of the statements either of the petitioners or of any witness or even of any co-accused imputed on any of the petitioners even remote knowledge of commission of scheduled offense and knowingly laundering of any proceeds of crime. Now, let me mark this. Moreover, there is not even any circumstantial evidence garnered in the entire investigation to remotely impute such prerequisite knowledge or mens rea, existence of which is essential, at least on prima facie basis, for taking cognizance of offense against the petitioners. Then, my lords, may go to page 49, para 54.
Yes.
The same test is applicable in the facts of the instant case. By the impugned order dated so and so, the special court for PMLA mechanically took cognizance of the alleged offense punishable under section 4 of PMLA qua each of the accused petitioner without even prima facie material showing existence of any mens rea or culpable knowledge with all or any of them of the subject scheduled offense investigated separately by crime branch so and so, or of any proceeds of crime emanating from the said scheduled offense. Neither there is any tangible evidence nor even any circumstantial material to impute culpable knowledge on the petitioners and to even prima facie conclude that they were either aware of the commission of the scheduled offense or the generation of the alleged proceeds of crime by or out of that scheduled offense. As per the material adduced, it cannot be even prima facie held that the petitioners had any reason to even have any reasonable doubt regarding commission of any alleged scheduled offense and generation of any proceeds of crime in relation thereto. The same is also fortified by the fact that none of the petitioners were made an accused in the scheduled offense. Even though the accused petitioners received in their bank accounts certain amounts at the instance of or from their close relative Shri so and so, the statement, if taken on their face value, do not satisfy or even prima facie basis the prerequisites for trying any person on allegations of money laundering, that is, mens rea, or culpable knowledge of the scheduled offense and proceeds of crime derived therefrom, and projection of such proceeds of crime as untainted. Now, my lord, this was a case where the allegation against mainly these petitioners was that એ લોકોના અકાઉન્ટ્સમાં જે ઓનલાઈન ક્રિકેટનું જે ક્રિકેટમાં બેટિંગ ચાલતું હતું તો એમના અકાઉન્ટમાંથી પૈસા ટ્રાન્સફર કર્યા હતા. They said they are not aware. My lord, my also argument in this case is that the current accused number 7 had absolutely no knowledge of what was happening. She was merely the wife of one of the accused who was signing as per the instructions of the husband. There is no material in this case on record placed by the prosecution to show that she actually had knowledge. Merely because money was transferred in her account by this, my lords, by this stretch of imagination. Today, if there is any allegation against any complainant, if that person even were to legitimately buy a phone from a mobile shop with an actual bill, that person who has received the money for selling the phone will also be an accused under PMLA, because he has received the proceeds of crime, and this is not the intention of the act. So in my humble submission, my lords, accused number 7 ought to be discharged in this matter because she had no knowledge. My lords, one more judgment on similar lines I may tender. My lords, it was a connected matter to the previous judgment. This was passed later on. My lords may go to para 30 at page 61, my lords.
Yes.
May I read, my lords?
Page?
Page 61, para 30. Though the respondents have dragged the matter by referring factual details, the reference of factual details which are discussed in the pleading nowhere proves any criminal activity, knowledge, or mens rea on part of the applicant so as to commit any offense, either scheduled offenses under IPC or under the PMLA. Then, my lords, they discuss the facts. Then, my lords may go to page
Para 29.
para 29. They are relying on some other judgment.
But that judgment has no relevance. Maybe it is pertaining to some insurance, chronic judgment.
That I'm not aware, my lords, why.
I mean, you have appeared in that matter. Anyway, you can continue.
My lord, it was my senior.
But your name is there.
No, my lord, my name is not there. I was not even with my current senior when this order was passed.
Mr. Diganth Popat is there.
That is my senior, my lord. Who Nihar Thakare, Mara Sahib.
Your senior was there.
Yes, my lord. He appeared. Yes. Then, my lord, para 32, page 66. Learned advocate for the respondent has explained the factual details of all the applicants, which is described in the charge sheet. So also in affidavit in reply by the respondent, contending that some of the transactions are not disclosed by some of the applicants in their books of accounts and to the income tax department, and therefore there is no reason to believe that the amount which transferred from different companies of main accused is proceeds of crime of the criminal activities by main accused. And if it is used for the business of the applicant, then the applicants have certainly committed offense under the PMLA.
It is on the same line.
My lord, yes, same lines, but I may only read the discussion on the next page, my lord, starting from the second line, however, the basic principle.
Yes.
At page 67, third line from the top. However, the basic principle to consider the involvement of any person in committing crime under the PMLA, if it is to be verified with provision of section 3 of the Act, and as is submitted by the respondent, is that if anybody either directly or indirectly, but knowingly and actually involved in concealment, possession, acquisition, use or proceed of scheduled offense, the fact remains that though quantum of amount of transactions are not small, there is no evidence to prove the involvement of the applicant either directly or indirectly in the commission of either scheduled offense or offense under the PMLA. And when there is lack of evidence regarding actual involvement or knowledge of all the applicants, with reference to concealment of proceeds of or direct involvement in any scheduled offense in any manner whatsoever, only possession of huge amount with its transaction through bank cannot considered as evidence so as to initiate the proceeding under the PMLA. Because I am also relying on this judgment to say that merely because my account is used to transfer money does not mean that I am actually aware of any crime being committed. That has to be shown by the prosecution to documentary evidence that I was actually aware and I have knowingly participated in this offense despite being aware. And my lord, last paragraph, para 40. My lords may have para 40, page 73. Anyone? In view of the above facts and circumstances, it becomes clear that by the impugned order dated so and so, the special court for PMLA mechanically took cognizance of the alleged offense punishable under Section 4 of PMLA qua each of the accused applicants without even prima facie material showing existence of any mens rea or culpable knowledge with all or any of them or of any proceeds of crime emanating from the said scheduled offence. And then, my lord, let me skip the middle portion. The next page, the fourth line from the top, starting from even though. Even though the accused applicants, my lords, may I have that? Even though the accused applicants received in their bank account certain amounts at the instance of or from Shri Afroz Hassan Fatta, the statements, if taken on their face value, do not satisfy even on prima facie basis that the prerequisite for trying any person on allegation of money laundering, that is mens rea, or culpable knowledge of the scheduled offence and proceeds of crime derived therefrom, and projection of such proceeds of crime as untainted. Before, my lord, to wrap up my submission with respect to accused number 7 would be that under section 3 of the PMLA, the as is considered by the honorable court, the one of the most important factors to be considered is mens rea or knowledge.
So that is your. Yes, prosecution. But it to be that Broadway by Indian Bank and the use your mind. Use your mind. Violation that we carried out was with respect to the example and with respect to the original cancel letter dated 29/2009. That was the purpose of which the loan was acted and then to the activity or in the term as given by the and the relevant evidence and the divergence on part of the present application. Firstly, with respect, there were two allegations with respect to the application. One is with respect to the divergence of the system of one by the flow, and second contains that divergence and finding the liquidity case of the sum. That 21st of June 2012, there comes an article transaction which was out to the tune of 1.2 crore, which gets transferred to the account of the present applicant. From there, on the very same basis, the 79 was transferred to the account of use number 2. And from there, it was again transferred on the very same day to a Shah Realcom for acquiring the shares of that company. The both transactions were utilized for purchasing the shares of another company, the actual fixed limited, and that again on the very same day. Date becomes very relevant for the present application. One is with respect to 70 lakhs out of the total amount of 1.2 crore. The remaining 40 lakhs was again transferred on the very same day into tranches, 20 lakhs and 25 lakhs to Gulman Kilpara. That is the name of the very same day, and again diverted to the same company Star Aircom for acquiring the shares in another company that is Champion Secretary, which is again currency. The purpose that was explained by the it was that it was for the payment and agricultural procedures for mainly gram, wheat, and groundnut supplied by the present applicant. However, it becomes relevant to these statement. In the and number 9 and 8. the state balance fund from the account of the actual and to the again and IDBI and Rajkot. For you to purchase a share of the page number is one of the funds. Yes, it is correct that the fund was used to invest in the share capital of another capital system. That comes the answer was they have said that it was one to save of some dollars or but that was not the case. Again, at question number 10, second paragraph of answer, these confidence will transfer from the account to savings account of my wife. Subsequently, the fund was used to pay where that equity paid for champion to better charge income at the face value of the in addition to the statement of other that while also relevant. It is at page 190, question number 5. Thank you. If your company, if you based on the oil profit supply of the agriculture revenue made by the last land, please take the review. Yes, the bills were supplied and yes, all the supply of agriculture made by last land, but presently I do not have any document or data with me with respect to the any documents that were made by the last land. I understand that I and my brother are many authorized signatories of the bank of Jeffrey are responsible for providing the documents, but we do not have any documents. On personally, I personally, I understand that I and my brother are many are responsible for providing the data, but we do not have any documents or data with us. Because they are not coming up with any documentary details or any bill to substantiate the data report for the supply or any goods that was provided by the present application to the company. And the date of acquisition of sale and transfer of sale funds also becomes relevant to their identified intent and purpose of transaction be not genuine and just to order the supply for acquisition. Then the demat account of Dalman and page number 365 to create and the account of the format page number 3 also becomes relevant because it has been signed by the present applicant for posting and even for the carrying out the transaction. One of the aspects is present was that EK has taken the document and the transaction being validated or an the custody of EK. The EK FIR came to be registered on 3rd of March 2021, just 2 years prior to the and no such document has ever been given to them or has been taken from the custody and given the transaction is 12 years old and document being custody of effective 12 years. It does not find the case. The two judgments that they are cited with respect to Hassan Bhatta and that pertains to the only coming of the or the taking out the judgment whereby the Supreme Court has interpreted it down and it has been used in the section 3 to be read as law. So the person need not be need not have to think as property being protected as untainted property. It has to be read as law. So this argument is that with respect to that judgment would not find a bail in this case. Now, another education with respect to the president and it also mentioned as page number 67 of the with all the evidences that have come on the board. In this two checks for CAT was carried was taken from this CAT eating out of the company. Two checks of 42.5 lakhs. These were deposited in the account of December 2 and 3 on the very same. From this fund, again 50 lakhs need to be transferred to this account and because again diverted to another company, Montana.
Only one question about knowledge.
The knowledge will come from certain university how that is guided by him. Second, that he has provided the
He is a housewife.
he thinks that I provided the company, whereas no goods has been provided or even any document comes upon the
That would be managed by the husband and family.
yes, claiming that I have provided the goods, thereby he has been assisting us to other those who come relevant for the reason because they have been claiming a lot of things for even for the treatment of the case of crime for even assisting others to do further. That even though the accounts were being managed by him, but they have been also claiming that similar thing that I have provided the goods to the company. I have the fund that has come to this account to other accounts would be for the transactions which were carried out by the for supply of goods or supply of groundnut or against some agriculture producer. So he has also been bringing with it is her knowledge for the intensive purpose again it has to be carried out to the trial only that testing will come on the that would warrant a trial or if testing and if criminal can do testing so that warrants the trial. And mobile and material are not essentially things are great in respect to that is my
My lord, only 2 or 3 points to rebut my friend's arguments. If my learned friend's argument is to be taken on record that without them producing any document to show mens rea, if I have to show it at trial, then the purpose of mens rea before cognizance would entirely be defeated. Now, one second. Now, I didn't interrupt. 1 second. My lord, with respect to my learned friend that she has made statements, my lord, what my learned friend read out was statements of the other two accused, saying that એમને gram supply કર્યું છે, બધું કર્યું છે. I may go to the accused, her own statement, which is made. My lord, page 595, if I may just read, my lord. Question number 6 and question number 7. Question number 6. Please state about any investment made in equities company by you, members of your family, and your companies, including Measures Champion FinSec Limited. Answer is, I do not know about any investment made in equity/company in my name as I have no independent source of income. This may be asked from my husband Shri Jitendra Kumar Gusabai Hirpara and his brother Dheerajlal Gusabai Hirpara. I had only signed the documents on instructions of my husband Shri Jitendra Kumar Gusabai Hirapara and his brother Shri so and so, and they are the beneficial owner of investment made in my name, if any. I further state that all the investments, if any, made in the entity/property/business in my name were done by my husband Shri so and so and his brother Shri so and so. I just sign on necessary papers, documents prepared by them as instructed by them. Then, my lord, the next question. Question number 7 at page 596 of Annexure J. Question 7. Please also furnish the details regarding transactions made by you with Champion Agro Limited and purpose thereof, including rupees so and so 1.2 crores received by you on 21/6/2012 from the loan bank account number so and so of Measures Champion Agro Limited maintained in IDBI Bank. Answer. I do not know about any transactions made in my name with Measures Champion Agro Limited and purpose thereof, if any. This may be asked from my husband Shri Jitendra Kumar so and so and his brother so and so. I may have signed some documents on instructions of my husband Shri Jitendra Kumar Gusabai Hirpara and his brother Shri Dheerajlal Gusabai Hirpara, and any transactions showing in my name should be explained by them, as every transaction in my name was done on their instructions only. In their statements, they say whatever reasons, my lord, rightly or wrongly, it is the two main accused who are giving the reason. She is consistently, this accused has stated that I am not aware of anything, and mens rea cannot be proved at the time of trial. There is no documents, no evidence. They, at the time of investigation, they could have posed a question to the lady that તમને ખબર હતી આ સેના માટે પૈસા છે, આ કંપનીના પૈસા લોનના છે નથી, એ લોકોએ કંઈ પૂછ્યું નથી સ્ટેટમેન્ટમાં. They accept the statement of the accused and then now they arraign her in the complaint. Therefore, my lord, the argument is that there is no mens rea. And with respect to the point raised by my learned friend with respect to Vijay Madanlal Chaudhary, that or je ibne sahab point kido, that I am not disputing that, because section 3 contemplates multiple activities, either possession or acquisition or different modes by which you may come in contact with proceeds of crime, and any one of those modes is necessary, not all. That is the context of Vijay Madanlal Chaudhary. However, the judgments relied upon by me have not been set aside by the Honorable Supreme Court, not challenged by the learned ED in relevant proceedings, and as such they have attained finality. And Vijay Madanlal Chaudhary has not read down the requirement of mens rea is contemplated in these judgments. Therefore, my submission would be that this honorable court is bound by these judgments. And my lord, sorry.
Why are you in hurry? Have patience. No. I thought this will be.
My lord, one more allegation which my learned friend read out at page 57, which is diversion of 1.85 crores. એ તો એમના રોલમાં જ નથી. એ તો page 90 what I read out. But this allegation is with respect to Dheeraj Lal Hirpara, not Vilas Lal. Happened.
Okay, chalo, yes, next.
Very good. Then, my lords, I may move to the discharge application of accused number 6.
Yes.
My lords, accused number 6 is Champion Agro Finance Limited. It's a sister concern of the accused number 1, which is the main company. My lords, the specific role of accused number 6, if I may go to page 88, my lords,
Of the complaint.
of the complaint.
Yes.
My lords, I may read page 88 at serial number 6, page 88 bottom. Messrs Champion Agro Finance Limited is the sister concern of Messrs Champion Agro Limited and has played a major role in assisting Messrs Champion Agro Limited in generation of proceeds of crime by involving in diversion and possession of cash credit funds of Messrs Champion Agro Limited availed from IDBI Bank Limited, Rajkot, to the tune of at least rupees 1.32 crores. Further, rupees 80 lakh were diverted from cash credit funds of Messrs Champion Agro Limited availed from IDBI Bank Limited, Rajkot, to the current account of Messrs Champion Agro Finance Limited for repayment of loan funds availed by Messrs Champion Agro Finance Limited. These above mentioned so and so, so and so. My lords, there are two allegations that 1 crore 32 lakhs they have transferred and rupees 80 lakhs which was given to accused number 1 is used by this company to pay off loan of for some other reason. Now, my lords, may turn to para 10.3, page 60 of the complaint.
Yes.
Now, my lords, at para 10.3, my lords, they show the entire chain કે કઈ રીતના 1 crore 32 lakh રૂપિયા પૈસા એ લોકોએ ટ્રાન્સફર કર્યા. 32 lakhs was transferred through check. Remaining 50 lakh were withdrawn in cash, then deposited in the account of accused number 6 on the same year. Now, my lords, they say that the allegation is that sorry, my lords, may also before that go to page 62, my lords, may in the same, under the table, my lords, the last paragraph, the second last paragraph, if I may read. Further, during the statement dated 7/12/2023, accused Dheeraj Lal Ji Hirpara stated that Champion Agro Finance Limited had availed a loan of rupees 35 crores from ILFS to buy back the shares of Messrs Champion Agro Limited lying with Sidbi Venture Capital Limited. The above mentioned rupees 1 crore and 32 lakhs transferred from cash credit account of so and so were used as repayment of loan funds availed from ILFS Services Limited. Now, my lords, પહેલી વસ્તુ તો આ જે સ્ટેટમેન્ટ પર જે રિલાય કરે છે ને 1 crore 32 lakh વાળું, I will also show that, my lords. That statement does not mention this amount altogether. If my lord may recollect, this allegation is with respect to two amounts. One is 1 crore 32 lakhs, second is 80 lakhs. That 80 lakh was transferred in two tranches. In the statement, they have only referred to those 80 lakhs, not with respect to this 1.32 crores. So this is not factually correct as mentioned in the complaint. I may just show that, my lord. I will.
Yes.
My lord, my learned friend would rely on Annexure F, page 314. This is the statement of Dheeraj Lal Hirpara.
Yes.
My lord, page 314, question 7. Please state whether funds from CC account number so and so of Messrs. Champion Agro Limited were used towards repayment of loan facility availed by Messrs. Champion Agro Finance Limited from ILFS Financial Services Private Limited. Yes, it is correct that funds from CC account number so and so of Messrs. Champion Agro Limited maintained at IDBI Bank Limited, Rajkot, were towards repayment of loan facility availed by Champion Agro Finance Limited from Messrs. IL&FS Financial Services Private Limited. Now, my lords, the second portion. Rupees 41 lakh on so and so and rupees 29 lakh on so and 39 lakh on so and so were transferred from CC account of Champion Agro Limited to my current account maintained at Axis Bank. Further, these funds were transferred to account number so and so of Champion Agro Finance Limited maintained at Axis Bank. And subsequently, interest of the loan availed by Champion Agro Finance Limited was paid to IL&FS Financial Services Private Limited. But nowhere here do they accept that 1 crore 32 lakh રૂપિયા જે claim કરે છે એ interest માટે છે. અને my second argument, my lords, would be that in any event they have not shown that from where this Champion FinSec this money has gone. I have submitted that this has gone towards repayment of loan to some other lender. At best, this may be a violation of my agreement with the bank that I am not to use these funds for some other purpose for which there are civil remedies available for the bank. But this may by no stretch of imagination can be argued to be money laundering, falling under Section 3 of the PMLA Act.
Yes.
Furthermore, my learned friend has not produced any documents with the prosecution. એ લોકોએ એટલું પ્રોડ્યુસ કર્યું છે કે પૈસા અક્યુઝ 1 કંપનીમાંથી નીકળીને અક્યુઝ 6 કંપનીમાં ગયા. બટ જ્યારે હું સ્ટેટમેન્ટ કરું છું કે અક્યુઝ 6 માંથી મેં પૈસા લોન ને ઇન્ટરેસ્ટ ભરવા માટે મૂક્યા છે, તો those documents are not produced by my learned friends in the prosecution. That actually that money has gone towards servicing, and that is to the best of my knowledge basis the record is not disputed by them. They say that તમે આ loan repayment કર્યું એ તમે that money you have used for purpose which was not sanctioned by the bank, and therefore it is money laundering. But I have not personally benefited from this. It is for the nature of the business was such that company 1 ને company 6 માંથી એ લોકો farmers ને બીજા બધાને loan આપતા હતા for them to enable to buy things such as seed, fertilizer, etc. so that they can grow the crops. And thereafter, when the crops are grown, we used to buy those crops. Now, this loan was given by company number 6. So, therefore, as such, the argument cannot be that this is a proceed of crime because I have not benefited from this. Whatever money is, I may have diverted that money, and at best, that may be a civil offense, if at all. But otherwise, this cannot fall under the ambit of Section 3 of PMLA because this has gone towards servicing of loan. My lords, this is with respect to the allegation of 1.32 crores. The second allegation, my lords, may have para 10.5, page 67. Page 67, para 10.5 of the complaint. Sorry.
Yes.
My lords, here the allegation is diversion of funds amounting to rupees 80 lakh from CC account number so and so of Champion Agro Limited, maintained at IDBI Bank, towards repayment of loan taken by Champion Agro Finance Limited from measures IL and FS Financial Services. Sorry, my lord. Essentially, rupees 41 lakh out of this 80 lakhs, my lord, 41 lakh in cash was taken by me, deposited in my account. The two accused, by me, I mean to say Dheeraj Lal Hirakara and only Dheeraj Lal Hirakara in this case. And thereafter, it is deposited in account of Champion Agro Finance Limited, and it is credited to the account of IL and FS Financial Services. That's apologies, my lord. They have mentioned the account number in which the money has gone in the trail. Through check, through RTGS, and this is all entire transaction is done through check. So therefore, my lord, this I have admitted even in my statement, and I have admitted here. The argument only is that, my lords, this money which was taken by me in cash, rather all amount which was taken by me in cash throughout my term with the company, my reason is, and the actual reason is that it is because I had supplied products and produce to the company, and I had taken money with respect to whatever I have supplied to the company, be it crops, fertilizers, etc. So therefore, the argument which I am trying to make is that both this rupees 80 lakh amount which I have taken from the company in cash, I may have used it to service the loan of some other company, but my argument is that that amount is taken by me in lieu of the produce I have supplied to the company. So therefore, my argument is that this is my money which I have then deposited in another company and then serviced the loan of the company. And they have also stated the fact that 12 વર્ષથી સાહેબ અમે આર્ગ્યુ કરીએ છીએ કે CBI તો 2020 માં આવી. What my contention is that CBI in 2020 has confiscated all my documents. It has been 4 years to that. More importantly, the allegations, whatever allegations are being made, are with respect to transactions in the year 2012. 12 વર્ષ પહેલાનું સાહેબ ડોક્યુમેન્ટ્સ માંગે, પુરાવા માંગે, જ્યારે ઓલરેડી એક બીજી ઇન્વેસ્ટિગેટિંગ ઓથોરિટીએ બધું મારી પાસેથી લઈ લીધું હોય, મારી પાસે એક્સેસ ના હોય, લિક્વિડેટર અપોઇન્ટ્સ થયા છે, they are running the company. So my lords, therefore that is a very heavy burden to discharge upon me કે 12 વર્ષ જૂનું તમે મને મોકલો બધું. Therefore, my lords, I would conclude to say that with respect to accused number 6, which is Champion Finance Limited, at best, there is a civil offense committed.
Finance or FinSec?
FinSec, sorry, my lord.
It is FinSec, your name.
Finance, my lord. The cost title ma Champion Agro Finance Limited, sir, at page 3. Accused number 6 is finance, my lord. If FinSec be a company, sir, finance be a company, sir.
You are the FinSec.
Sorry, I apologize, my lord. That is an error on my end, my lord.
So it is FinSec. You argued for FinSec.
I argued for accused number 6, which is Champion Agro Finance. Apart from Champion Agro Finance, FinSec is not an accused before, my lords, in this matter.
You have written.
That, my lord, my apology. That is a typographical error. Since there are two companies, Lakhwama bhul gayi thi, but it is Champion Agro Finance Limited, my lords.
Then you have to correct it.
I will do it, my lords.
Other allegations are similar.
Similar, my lord.
1.32 and 80 lakh.
That is with respect to accused 6 is what I've argued. Champion Agro Finance ની મેં આર્ગ્યુ કરી છે સાહેબ. એ 1.32 અને 80. Champion FinSec એ accused જ નથી.
By this time you can correct it.
Yes, my lord. I will do it, my lord.
Yes, what do you have to say?
That they will not and not cause it money or like 140 Not sanctioned for the purpose of reserve of company champion agro. Then to be paid out of whole amount of other companies. That will certainly fall within this statement that is not relevant to what he was pointing out, that there is no purpose with respect to this or no substantial proof that has been kept on record by the prosecution with respect to the diversion of funds to the tune of 1.32 crores. The statement was that he read was not relevant with respect to that. I would point out that at page number 60 of my complaint, I've the complaint specifically narrate with respect to how the piece of crime to the tune of 1.32 crores was diverted and utilized for the repayment of funds of some other company. The date here would be relevant because the transaction would be carried out on the very similar date on which the funds were taken out from the company. Firstly, on 28th of December 2011, the funds of Champion Agro get diverted to Champion Agro Finance Limited directly to the tune of 32 lakhs. And again, on 27th of June 2012, there is a cash withdrawal to the tune of around 1 crore, which gets deposited into two tranches. One with 50 lakhs each within the account of accused number 2 and accused number 3. From there, it gets transferred on the very same day to the accounts of Champion Agro Finance Limited. And again, it was utilized for repayment of the account of of the loan which was taken from ILNFS. So again, purpose was not for the business purposes of Champion Agro, but for the repayment of some loan account of some other company, which is not the purpose of for which the loan was sanctioned. And claiming it to be a civil wrong is not but tenable at this stage. And it is a mere matter of convenience for them to say that it is for the civil wrong. Again, sir, at page number 67 of the complaint, the relevant transaction for diversion of amount of 80 lakhs would be relevant, whereby 41 lakh gets transferred from the cash credit account of the Champion Agro to RTGS into the account of accused number 1, and from where it gets transferred to the Champion Agro Finance Limited for the repayment of again of the loan amount. So that was never the purpose for which the loan was sanctioned, and again it would certainly fall within the definition of diversion of the amount.
Page 57 is pertaining to
67, pardon. 67.
67.
It is with respect to this 80 lakhs that was transferred. The statement that he was reading was with respect to this accusation. At page number, at page 314, the statement that he read was with respect to this allegation. 41 lakhs would find mention with respect to this transaction. The date was also would be certified with at page number 314. Again, sir, the loan agreement document. The RMD W would be relevant because the purpose of loan was duly mentioned, and this has been agreed upon by the company Champion Agro and the directors. So anything which is in contrary to that would certainly fall within the ambit of the criminal liability that has been placed upon the president. And this company has assisted the laundering of crime to the in two tranches, 1.232 crores and 80 lakhs, and that is where their role would come in. That would.
Rest of the argument says.
And similar would be the role for the director of the company who is at accused number
Let him argue.
5. That subject to this.
My lord, just two things in rebuttal. One is that, my lord, in their complaint, what I pointed out to my lord, where they are saying that ये तो बीजा कोई context में 80 लाख ना regarding statement आप्યું છે. In the complaint with respect to allegation of the 1.2 crores, they have written at page 62, the last paragraph at the bottom, that second last paragraph, that during statement dated 7/12/2023, that very same statement જે મેં વાંચ્યું, accused Dheerajlal Hirapara stated that Champion Agro had availed a loan of so and so. The above mentioned 1 crore and 32 lakh transferred from crash credit so and so were used as repayment of loan funds. મેં એવું ક્યારે મારા સ્ટેટમેન્ટમાં નથી કીધું. મેં 80 લાખનું એડમિટ કર્યું છે કે એ બીજી એક લોનના સર્વિસિંગ માટે આપ્યા છે, but not with respect to 1.32 crores. That is one, my lords. And secondly, my lords, they are the argument that that non-compliance of a term of a loan falls under the ambit of PMLA. My lords, in that context, I may only read the definition of proceeds of crime, which is the subject matter of proceedings under the PMLA. My lords, section 2U, proceeds of crime, if I may read, my lords. Proceeds of crime means any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense or the value of any such property or where such property is taken or held outside the country. Because as I would only reiterate that I have not benefited personally or I have not misused that funds for any other purpose. I have only used it to address the loan of another entity. So therefore, my submission would be that this would not fall under the definition of proceeds of crime itself or under section 3 itself. Now, my lords, accused number 5, Kantilal Nanjibhai Tarpara.
Long movie, sir. It's a long movie.
Currently, the fashion is to release long films.
હા,
4-4 કલાક ની આવે
4-4 કલાકની છે એટલે આ એ જ છે. I may name it ધુરંધર જેવી જ છે. And because this is one of the direction matters. So you all can, if you, I don't suggest, you can sit here, but it may take the first half. It will continue because he has other 3.
My lords, I have indicated to my learned senior that first half, my lords, I may take to complete all
Come
that.
in the second half.
You can come in.
That will be 3 o'clock. My lord will resume at 3 o'clock or
3 of them.
3 o'clock.
I'm representing liquidator. I'm representing liquidator.
You don't have anything to say.
So far as the framing of the charge is concerned, I want to say this.
But that is not, today I am hearing discharge
Yes,
application.
yeah, I understand, but the stage is shown as framing of charge and discharge, that's right.
Yes, yes, it is for framing of charges.
I-
It is because of you.
એમને સાહેબ એમને જ point out નથી
You
કર્યું
should have pointed out the correct fact before the High Court. And this is the third or fourth matter where liquidator do not tell the correct facts. 226 was already complied by this court in writing.
I am not in fact, but I am not,
Arey, you were the party there.
I am not that, okay.
Advocate might be anyone, but the party is liquidator.
That is correct. He is-
And it is the say of the ED that it was brought to the notice. But liquidator are in very much hurry. And they miss and they don't even bother to make the parties, who are the parties here. That is the difficulty.
તો સાહેબ on a different note, I was informed in fact કે આ મેટર જ્યારે હાઈકોર્ટમાં હતી ને ત્યારે કોલ આઉટ પણ નથી થઈ.
Maybe that we are
એટલે-
now that has gone, everything is gone.
Very good.
We'll take it after 2-3 minutes.
Sure. Do it, my lords, from their own complaint.
Yes.
My lords, I may first read the specific role as mentioned in the complaint. That is at page 87 of the complaint.
Page
87.
Yes.
My lords, page 87 in the box at 5, Kanjiral Nanjibhai Tarpara. Kantiral Nanjibhai Tarpara is the director of Messrs. Champion Agro Finance Limited since 9/11/2009, which is involved in diversion and possession of cash credit funds of Messrs. Champion Agro Limited availed from IDBI Bank to the tune of at least rupees 1.32 crores. My lord, allegation એવું છે કે તમે કંપનીમાં ડિરેક્ટર છો જેમાં 1.32 કરોડ ગયા છે. Then my lord, second point. Further, rupees 80 lakhs were diverted from cash credit funds of Measures Champion Agro Limited availed from IDBI Bank by directors of Champion Agro Limited to the current account of Champion Agro Finance Limited for repayment of loan funds availed by Champion Agro Finance Limited. These above mentioned diversions of cash credit funds of IDBI Limited availed by Champion Agro Limited towards Champion Agro Finance Limited, a directorship of Kantilal Nanjibai Tarpara, caused NPA of accounts of Champion Agro Limited and loss of rupees 58.6 crore to IDBI Bank Limited. Though he claimed that he was not involved in day-to-day business of Champion Agro Finance Limited, this claim is highly suspicious, as Kantilal Nanjibai Tarpara is old friend of accused Dheerajlal Gusabai Hirpara and also director in other sister concerns so and so, so and so, so and so. Emma, my lords, the last entity which they name, Messrs. Om Fresh Fruits Private Limited. That is, my lords, I mark that name because that is relevant. I'll come to it a little later, my lord. Thus, it can be easily inferred that it was in his complete knowledge about all the diversions and unauthorized use of bank funds by accused directors of Measures Champion Agro Limited. Despite this, Kantilal Nanjibai Tarpara assisted other accused in generation of proceeds of crime. Because how can knowledge be inferred? Either the accused has knowledge or the accused doesn't have knowledge. It is for the prosecution to show that the accused was aware. The reason why I showed the name of Om Fresh Fruits Private, my lords, because there is an allegation pertaining to that entity also, which is relevant for other accused, which I'll come to later on. But આ ઓમ ફ્રેશ ફ્રૂટ્સમાં બીજા 5 ડાયરેક્ટર હતા, તો એ લોકો એમના સ્ટેટમેન્ટ લે છે, એ ડાયરેક્ટર્સને અક્યુઝ નથી બનાવતા, બટ merely because this person is a friend of the main accused, આમને અક્યુઝ બનાવી દે છે. And they are only saying that they are inferring કે knowledge હતું. On merits, my lords, the true allegations are of 1.32 crores and 80 lakhs. In the previous entity's discharge application, which is Champion Agro Finance, a same allegation.
You are director of Agro Finance,
Yes, my lords.
in which 1.32 crores came from Champion Agro.
Yes, my lords.
And second amount is 80 lakh,
Yes, same. Yes, my lords.
which came to your entity where you are director.
Yes, my lords. My lords, the previous discharge application, which my lords heard of 1.32 crore and 80 lakh, same allegation, same transaction. The only difference for this accused is that હું જે કંપનીમાં પૈસા ગયા ને, જે ચેમ્પિયન એગ્રો ફાઇનાન્સમાં હું એમાં ડિરેક્ટર છું. Now, my lords, from their own documents, their own pleadings, it is seen that both these amounts, 1.32 crore and 80 lakh, were transferred, withdrawn, and sent by some other accused, which is Mr. Dheerajlal Hirpara. એક બી જગ્યાએ એલિગેશન એવું નથી કે કાંતિલાલે આઈધર કશે સહી કરી છે કે પછી એમને આ ચેમ્પિયન એગ્રોમાંથી પૈસા ટ્રાન્સફર કર્યા છે. The only allegation against him is that તમે એક એન્ટિટીમાં ડિરેક્ટર છો અને તમે એમના જૂના ટાઈમથી મિત્ર છો, એટલે તમને આ બધાની નોલેજ હતી. Now, my lords, if this is the case, then in all entities, how many ever directors are there? All of them would have implied knowledge merely because being a director of that entity. Then they have to at least answer that why are they not made as an accused? Because there is no material on record to show that Kantilal Tarpara was himself aware of anything. I will also show his statement, my lords, what he has stated to prosecution. But this also, their own complaint specific role mein કહે છે કે knowledge can be inferred. Therefore, even the prosecution admits that Mr. Kantilal Tarpara had no personal knowledge. They are assuming that he had knowledge, which is, my lord, not the threshold required under section 3 of the PMLA. My lords, I may go to his statement. It is Annexure R. My lords, may have page 1913. My lords, may I read the questions in his statement and answer?
Page number.
Page number 1912, annexure R. My lords, may I go to question 6. My lords, may I read? Question 6. How do you know Shri Dheerajlal Sabai Hirpara? Answer. I state that I met Shri Dheerajlal Ji Hirpara in college and we are friends since then. I joined Champion Agro Limited as store manager in 2005. In 2009, when Dheerajlal Hirpara was planning to establish a sister concern of Agro Limited, namely Champion Agro Finance Limited, he offered me to join his company as director. I was still working in Champion Agro Limited, and for the sake of old friendship, I accepted his offer and joined Champion Agro Finance Limited in 2009. Then, my lords, may go to question 10. Question 10. Please explain about utilization and purpose of below mentioned credit into account number so and so of Champion Agro Finance Limited maintained at Axis Bank Limited. Now, my lord, the answer to that. I state that I was the director of Champion Agro Finance Limited only on paper. I was not involved in day-to-day business of Champion Agro Finance Limited. All the books and bank account of Champion Agro Finance Limited was managed by Shri Dheerajlal Gusabai Hirpara and Shri Jitendra Kumar Gusabai Hirpara. I had only signed the documents / checks on instructions of Shri Dheerajlal Gusabai Hirpara and Shri Jitendra Kumar Gusabai Hirpara. Thus, purpose and utilization of above mentioned transactions in account number so and so of Champion Agro Finance Limited maintained at Axis Bank may be asked from Shri Dheerajlal Gusabai Hirpara and Shri Jitendra Gusabai Hirpara. And then, my lords, question 14, which is, do you wish to say anything more? Ema same vastu repeat kare chhe. Okay, I also state that for effecting transactions, acquisition of assets of any type, the documents, financial instruments, deeds, checks, vouchers, etc. related to Champion Agro Finance Limited, whenever required, were prepared by Shri Dheerajlal Gusabai Hirpara and Shri Jitendra Kumar Gusabai Hirpara, and I only signed as instructed by them, and they were the ultimate beneficiary of all transactions effected by my signature. Now, my lords, coming to the allegation against him in this complaint, we are limited only to the scope of the two allegations made against him, which is of 1.32 crore and rupees 80 lakh. My lords, at the cost of repetition, I may show from their complaint with respect to the trail, ये लोगों को कैसा पैसा कौन है उपाड़े and क्या गया. First, my lords, may go to page 60 of the complaint, 60. Emma, my lords, may go to page 62 of the complaint.
Page 62.
Page 62, my lords, एक table, एक flowchart बनाया हुआ था. My lords, a table માં જે first allegation છે 1,32 લાખ નું છે. My lords may see that the first column, which is 1 crore, that is through check deposited by Dheerajlal Hirpara and Jitendra Kumar Hirpara. એ નીચેના જે બે ટેબલ છે વચ્ચેમાં cash deposit લખ્યું છે. એમને cash ઉપાડ્યા ને એમને પૈસા જમા કરાયા છે Champion Agro Finance માં. Not the present accused, which is Kantilal. And the second table, which is 32 lakhs, એ બી ડિરેક્ટલી આ જ અકાઉન્ટમાં ફાઇનાન્સમાં ડિપોઝિટ થયા છે જે કાંતિલાલે નથી કર્યા. Nowhere have they also alleged in either in the complaint or in the documents that this accused has himself done this or entered this transaction. Even with respect to the 80 lakhs, my lords, that also flowchart is at page 67, 10.5. Eva, the flowcharts are at 68 and 69. બંનેમાં my lords ધીરજલાલ હિરપરાએ કર્યા છે. કેશ ઉપાડીને એમને જમા કર્યા છે, not કાંતિલાલ. Therefore, there is absolutely no iota of evidence on record to show that Kantilal Tarpara was either aware of the transactions or that, at least with respect to the allegations pertain to this very complaint, irrespective of what else he may be aware or not aware of for the company, but આ બે transactions માટે તો એમનું કોઈ involvement જ નથી બતાવ્યું. And the only allegation which they make in the specific role is that because he is a friend and because he is director in other companies, it is inferred that he has knowledge. My lords, my submission, honorable submission would be that as per the judgments of the High Court, mens rea is very important in section 3. And without establishing mens rea, the prosecution cannot proceed and an innocent person cannot be subjected to trial. Merely because the prosecution infers mens rea, they have to establish and prove it that he was actually aware of the transactions. And in his statement, the accused says કે મને તો જ્યાં કહેતા હતા ત્યાં સહી કરતો હતો. In fact, he was store manager. મને તો કીધું એટલે director બનાયા. એટલે મને કોઈ જાણ નથી. અને that is the statement that only Dheerajlal Hirapara and Jitendra Dhirapara are aware of the transactions of the companies is borne out from the record, because consistently in statements of all accused, જે બીજા બધા accused કહે છે કે આ બેને જ બધું ખબર છે ને આ બે કહે છે કે અમને જ બધું ખબર છે. So therefore there is no inconsistency. And if merely his being a director is a reason why he is arraigned as an accused, then the prosecution will have to show that why are all directors in all other sister concerns are not made as an accused, and why are they cherry picking only friends of the main primary accused. Therefore, my lords, my submission would be that for Kantilal Tarpara, that he has no mens rea, he had no knowledge of the transactions, and therefore section 3 of the PMLA does not apply to him, and therefore he should be discharged by this honorable court.
Page 67, what you wanted to point out?
My lords, page 67, my lords, may have page 68 and 69. એની પાછળના જે બે tables છે ને, એ બંને tablesમાં, my lords, the second allegation is 80 લાખ રૂપિયાનું, કે આ કાંતિલાલ તરપરાની કંપનીમાં પૈસા ગયા છે, એટલે therefore કાંતિલાલ તરપરા has committed money laundering. My lords, આ બંને ટેબલમાં એ લોકોના ટેબલ્સમાં છે કે ધીરજલાલ હિરપરાએ પૈસા ઉપાડ્યા છે અને પૈસા જમા કર્યા છે. તો they have to, when they merely making allegation against the person is not enough, they have to show specifically how Kantilal Tarpara himself had knowledge of the transaction or had assisted in the transaction. Merely being a part of the company is not sufficient, my lords, is my submission, my lords, to this honorable court. અને 80 લાખનું તો માય લોર્ડ ધીરજલાલ હિરપરા પોતે એડમિટ કરે છે કે મેં ઉપાડીને મેં બીજી કંપનીમાં સર્વિસ કર્યા છે. તો હાઉ કેન ધેટ એલિગેશન બી મેડ અગેન્સ્ટ અનધર અક્યુઝ સેઇંગ ધેટ તમે આ મની લોન્ડરિંગ કર્યું છે, when one co-accused is already accepting and this person is saying કે મને ખબર નથી એમને કર્યું છે, જેને કર્યું છે એ કહે છે કે મેં કર્યું છે. તો where is the question of arraigning Kantilal Tarpara as an accused?
He has not been made merely because he is a director in the company, also because he has been the recipient of proceeds of crime. He has been made director in the company and he has been getting his 10,000 cash as a director for being there as a director. And firstly, secondly, he has been given shares in the company Champion Agro Finance Limited. He was holding 47,000 shares, and his wife was also holding the shares of around 1.7 lakh shares in the company. In addition to this, he was also given the shares of another company, Home Fresh Food, to the tune of around 85,000 shares. It is not implicit that he has been the director and carrying out the transaction. Also, he was a recipient and getting the advantage from some other company for
fulfilling all the desires and the whims and fancies of the other directors. Secondly, sir, his statement would be relevant. I would be reading his statement at 1911, page number 1911, question number 1, answer to question number 1. After completing my graduation, I worked as a store manager. Later in 2005, I joined Champion Agro. In 2009, Neeraj Nirpara offered me the position of director of Champion Agro, and I accepted this offer. I was paid 10,000 in cash as a director. I am still one of the directors of Champion Agro, and however, as the company has been NPA, I am not getting any salary as a director. So he was made the director for carrying out or assisting the other accused person for diversion or layering of the proceeds of crime. Secondly, he was being advantaged by making him a director in Home Fresh Food, so that his position or whatever he has been doing on behalf of the accused number 2 and 3 in this company, the benefit was being transferred or diverted to him through some other company, Home Fresh Food. He has not made any capital investment or anything in Home Fresh Food. He was getting the advantage from there. He was shareholding partner in that company to the tune of 85,000.
What he got from Home Fresh Food?
Sir, the MGT 7, if Your Honor would, and at page 5861 of the RUD, sir, he would find the MGT 7 form of Home Fresh Food, whereby his shareholding he was getting his, at page 5841 of the complaint, the honor would find 5841, the MGT 7 form, whereby his shareholding pattern as a director would be relevant, because in that company, without any investment, he was given 85,000 shares of that company. Because he was the receipt, and Home Fresh Food has also received the proceeds of crime. That would be relevant for, because accused number 2 and 3 would be relevant for that. Also, he would be relevant because he was the director of the Champion Agro and the transaction was carried out. And the instance of the but he was also
My lords, to simply answer my learned friend, my lords, there are in their document it બતાવે કે બીજા shareholders બી છે કંપનીના. So if merely being a shareholder of a company is a crime, then my lords, possibly every listed entity in India, everyone would be a crime if any entity commits a crime. So therefore,
Director as an entity.
no, I will also, my lords, that argument also I will disprove. Right now, they have come up with the argument that તમે shareholder હતા. But should this not have been part of the specific role of the accused, and there has to be specific allegation against him in the complaint, saying that તમે આ shareholding, આ કંપનીમાં shareholding લીધું છે, જે તમે પૈસા અહીંયાથી લીધા છે કે X જગ્યાએ વાપર્યા છે, and therefore you are made as an accused. I may again, my lords, read the specific role of Kantilal. My lord, that specific role is at page 87. My lord, એમાં આ લોકોએ સ્પેસિફિક રોલમાં એ લોકોએ એલિગેશન જ નથી કર્યું કે તમે બીજા કોઈ એન્ટિટીમાં શેર હોલ્ડર હતા, therefore this complaint is filed against you. There, I am only limited or concerned, and I can only answer what allegations are made against me. The only allegation made against him is with respect to 1.32 crores and 80 lakhs. Two allegations. Hi, he is a director. That I have read out. And third, કે તમે director હતા entity-માં. Now, my lords, with respect to both these allegations of money, as proven by them themselves, કે બીજા accused their transactions કર્યા છે. મને તો ખબર બી નથી. And with respect to him being a director, they may show even one judgment, which says that merely because you are a director in a company, you are liable to be made as an arraigned as an accused for money laundering. And therefore, they may answer કે at least, my lords, 5 entities they have mentioned. કે આ 5 એન્ટિટીમાં ડિરેક્ટર હતા, તો 5 એન્ટિટીમાં બીજા ડિરેક્ટર્સ બી હતા. એમ કરતા કરતા why have they not joined every director as an accused? my lords, the answer to this is reflected in their own specific role allegation, saying that they are, thus it can be easily inferred that it was in his complete knowledge. And because he says કે હું ધીરજલાલનો ભાઈબંધ છું, I am his friend and we were together in college. It is only to harass him, and it is only because he is the friend of the main accused. They are inferring knowledge and then arraigning him as an accused. Otherwise, by this logic which the prosecution is trying to forward, if knowledge is to be inferred, then my lord, even independent directors who have nothing to do with day-to-day affairs of the company would be arraigned as accused. So therefore, my lords, this argument made by the prosecution is only unsustainable. And if they are now making new allegations, okay, because you are a shareholder of Home Fresh Fruits, that should have been disclosed by them, shareholding વાળું. More importantly, I will come to that Home Fresh Fruit allegation, my lords. એમાં allegation શું છે કે તમે ડેટ વાળી કંપનીને આ ચેમ્પિયન એગ્રોમાંથી પૈસા ઉપાડીને તમે બીજી કંપની ખરીદી, જે તમારે નતું કરવાનું. That is not for the funds are sanctioned for. એવું નથી. કાંતિલાલ personally, where have they alleged that મને પૈસા મળ્યા છે, કે મેં કઈ પ્રોપર્ટી ખરીદી છે, શેર્સ ખરીદ્યા છે, કે મેં પ્રોસીડ્સ ઓફ ક્રાઇમ થી કઈ બી કર્યું છે? There is absolutely no allegation. સાહેબ 10,000 રૂપિયા તો ડિરેક્ટરનો પગાર તરીકે મળતો હતો.
That I clear that page number 30, para page 3.10. He asked about what is he asked about his shareholding in Home Fresh Foods. He stated that he and his wife, when Sojitra shares holder of approximately 30% share of Home Fresh Foods. For the remaining shares of 7.21 are given to Kankilal and Sirapara, who was employee of Champion Agro, and 27% share was given to him by Champion Agro. Thus, the actual beneficiary of our entire shareholding are his brother, and also because 7.21 are also being.
My lord, આ સ્ટેટમેન્ટમાં તો ઉલટાનું એવું કહે છે ધીરજલાલ કે મેં ગિફ્ટ કર્યા હતા શેર. If the allegation is that you are in receipt of proceeds of crime, would they not have to show that I had purchased those shares from proceeds of crime? If someone is making a gift to me,
He has been benefited in some other company. That is a
no, but my lord, then that has to be specifically pleaded. They may gather 10,000 facts, but after gathering 10,000 facts, the prosecution may decide કે મને તો આ 100 facts પર જ આ લોકો સામે proceed કરવું છે. Where is the specific role, or where is the allegation that because you are a shareholder in Home Fresh Fruits that you are entitled to be proceeded against? They may show from their complaint where is that allegation against me. They can't read pieces and parcels of information or facts in a 150-page complaint and say કે તમારે તો એકો એક વસ્તુ લીટી બાય લીટી આન્સર કરવાની હતી. મેં સ્પેસિફિક રોલ વાંચ્યો છે, એમને અલેજ કર્યો છે. સ્પેસિફિક રોલમાં એમને જ અલેજ નથી કર્યું કે શેર હોલ્ડિંગ ઇઝ અ ગ્રાઉન્ડ ફોર arraigning him as an accused. Now they cannot raise at this stage at discharge application new grounds or new facts which are. My lord, but that has to be that. તમે કોઈની સામે સાહેબ એફઆઈઆર ચાર્જશીટ કરો તો એમના રોલ.
or the two transactions for the Champion Agro and Home Fresh Foods also has been entered into.
But my lords, it is not just my lords. My submission is to my lords to concisely submit my arguments, my lords. First is that the only allegations against the accused and his specific role is already mentioned in the complaint. The prosecution at the stage of discharge application cannot now make fresh allegations which are not specifically pleaded as the accused's specific role, because I have had no opportunity to answer that. Second argument, my lords, is that there is no mens rea of Kantilal, because there is no proceeds of crime which he has personally benefited from. He has neither shown any property as tainted or untainted. He has neither claimed that he is in receipt of any proceed of crime. Prosecution is alleging that because you got shareholding, that is a proceed of crime. But I have not received any personal benefit, and I am not aware of any transaction. And the two allegations only made by them are already answered by other co-accused by themselves, saying that આ તો બીજા જ બે લોકોએ કર્યું છે. So therefore there is absolutely no evidence. And my lords, most important would be their averment, where they say that we are inferring knowledge, which in my submission is not permissible at all.
in order to affect the other year, way to transition from for the repayment of the loan on account of the campaign agro financial state. Yes, the cash account was diverted from by consumer movement fee. It has reached account number six company campaign agro financial state, and from campaign agro is under the directorship. My payment was made to the bank for the repayment of loan. This was not the purpose of loan sanction amount for campaign agro finance.
સાહેબ તો હવે આર્ગ્યુમેન્ટ શું છે કે શેર હોલ્ડિંગ મળ્યું છે એ પ્રોસીડ ઓફ ક્રાઇમ છે કે તમે ડિરેક્ટર હતા ને એમાં પૈસા જમા કર્યા છે એ પ્રોસીડ ઓફ ક્રાઇમ છે? કારણ કે બંને બાજુ સાહેબ ના થઈ શકે. એમનું એલિગેશન એક જ છે કે તમે આ કંપનીમાં પૈસા આયા જે લોનના પૈસા તમને સેન્કશન પર્પસ માટે યુઝ નથી કર્યા. એન્ડ ધેટ ઇઝ ધ ઓનલી એલિગેશન અગેન્સ્ટ ધીસ અક્યુઝ. શેર હોલ્ડિંગનું તો એલિગેશન જ નથી. બટ ધેન માય લોર્ડ્સ દે મે આન્સર. તો if that is the logic to seek assistance from a director, then they may answer right now why are other directors not made parties or why is their assistance not sought. Statements લીધા છે, એવું નથી statements નથી લીધા. તો statement લીધા પછી why are they not arraigned as an accused? Sorry, my lord. Now, my lords, Gunwant Gusabai Hirapara, he is the brother of the main primary accused people.
So now two accused are there, main.
My lords, majorly two, Jitendra Kumar and Dheeraj Lal, 2 and 3. એ 2 and 3 ના જે my lord discharge છે ને એમના allegations almost 50-60%. The facts are already covered in all the other applications. So those otherwise also may not take long. Now the only independent discharge application which my lords may consider is before the primary accused, this Gunwant Gusabai Hirpara, who is accused number 4. Now my lords, his specific role is at page 86.
Yes.
My lords, may I read page 86 of the complaint? Page 86, Gunwant Gusabai Hirpara. Gunwant Gusabai is the brother of accused directors of Champion Agro Limited and has played a major role in diversion of 25 lakh through his savings account. Gunwant Gusabai Hirpara opened demat account in his name where the proceeds of crime to the tune of rupees 25 lakh were deposited in the form of shares of Messrs Champion Finsec Limited. Further, Gunwant Gusabai Hirpara purchased lands during 2010-11 in cash only, and he could not explain the source of funds to acquire the said properties. Thus, the lands purchased by Gunwant Gusabai Hirpara have been attached under section so and so. Because these are the only two allegations against him. First, I may deal with the allegation of 25 lakhs, my lords. For that, my lords may turn to page 40, para 8.8.
This is finance or FinSec?
My lords, this is shares of Finsec. May I read, my lords? Page 40 of the complaint, para 8.8.1. May I read, my lords? 8.8.1 facts related to credit of rupees 25 lakh in his savings account from savings account of Vilasben J. Hirpara. The accused Gunwant Hirpara stated that he does not know about any transaction made in his bank account as he has never accessed his bank account. His savings account number so and so was opened by Dheeraj Lal Hirpara and Jitendra Kumar Hirpara, and that for effecting transactions, acquisition of assets of any type, documents, financial instruments, deeds, checks, vouchers, etc., whenever required, were prepared by his brothers Dheeraj Lal Hirpara and Jitendra Kumar Hirpara, and he had only signed as and when instructed by them. My lords, in his deposition, sorry, not in his deposition, in his statement before the authority, page 716, question 5, annexure N. May I read, my lords? Yes.
Page number.
My lords, page of the statement, my lords. I was reading, my lords, page 40 of the complaint, para 8.8.1.
So
Now, my lords, I am reading his statement made before the authority, page 716 of annexure N, question number 5.
now N,
N, my lords.
716.
Yes, my lords. My lords, question 5. Whether you have received rupees 25 lakh from Mrs. Vilasben Hirpara on 21/6/2012. If yes, please provide the details and purpose of the leave. I do not know about any transactions made in my bank account as I have never accessed my bank account. I completely depend on my brothers, Shri Dheeraj Lal Hirpara and Shri Jitendra Hirpara. Whenever I need money, my brothers provide me the money in cash. Further details and purpose of this transaction of rupees 25 lakh may be asked from my brothers, so and so and so and so. I had only signed the account opening form of the bank account and checks issued on instructions of my brother, so and so and so and so. My lords, they have not shown કે આ 25 લાખ જે વિલાસબેને ટ્રાન્સફર કર્યા છે વિલાસબેનને ક્યાંથી મળ્યા છે. The allegation is that if it is a proceed of crime, they may at least show that when one accused is transferring money to the other accused, then the accused who has transferred the money has to have received the money, or there has to be an allegation that that money is itself proceeds of crime. मतलब વિલાસબેન has transferred to ગુણવંતભાઈ, ગુણવંતભાઈએ shares લીધા છે. ના ગુણવંતભાઈએ શેર્સ લીધા છે એ દેખાય છે, વિલાસબેને ટ્રાન્સફર કર્યા છે ગુણવંતભાઈને એ દેખાય છે, પણ વિલાસબેનને પૈસા ક્યાંથી મળ્યા અને વિલાસબેને how is that proceed of crime? They may answer that because that is not borne out from the record. More importantly, my lords, this accused says that મને તો જ્યાં મેં અકાઉન્ટ સ્ટેટમેન્ટ ને બધું જ્યાં કીધું છે ત્યાં સહી કર્યું છે. The prosecution at the time of recording a statement could have posed this question when an accused gives a statement કે આ મારા ભાઈઓને ખબર છે મને પૈસા કેમ મળ્યા છે કે મારા નામમાં શેર્સ લીધા છે મને નથી ખબર. Then they could have asked the brothers that this is that did you transfer it, or are you the beneficial owner, did you take that money? This is only to show that there are ways and methods of finding out knowledge, because my lords, my entire case for these other accused turns on knowledge. Because if I say that મને આ ટ્રાન્ઝેક્શન ની નથી ખબર, મને તો જ્યાં કીધું છે ત્યાં સહી કરે છે, so the prosecution then has to at least find out whether that is true or correct. I may be even false. For a moment, I may assume that I may have falsely stated. But it is not that the prosecution is powerless to find out the truth. They could have posed these questions to the other accused, saying that were you the ones who transferred this amount, or are you the beneficial owner? Is it your specific role? Who has done this? But these questions, after I make a statement to the ED and say that મને આ 25 લાખનું ખબર જ નથી, મારા ભાઈઓએ કર્યું છે, અને તમે ભાઈઓને જઈને પૂછો નહીં, અને પછી તમે કહો કે તમને અક્યુઝ બનાવીએ છે, then my lord, there is no knowledge imputed to me. And then the burden falls on them to show that how are they inferring knowledge, or how are they establishing knowledge that I am aware that this is a proceed of crime, or that I am aware that these transactions are happening at all, if at all. Then my lords, the second allegation against him is that એમને 3 property ખરીદી છે. My lords, on page 40 of the complaint, I may continue to read that at page 40, 8.8.2. Facts related to property registered in his name.
Yes.
He stated that 3 agricultural properties mentioned in table number 8.8.2 below are registered in his name using his own funds. Then my lords, table માં એમને 3 property list out કરી છે, અને એના conclusion, my lords, is very important, which I may read at page 41 of the complaint. The above mentioned 3 properties were purchased in cash only, and accused Gunwant Hirpara could not produce any cogent evidence or document to justify source of funds to acquire above mentioned 3 properties. Hence, it forms a potent reason to believe that these properties were also purchased using diverting loan funds availed by the directors of Champion Agro Limited, as the loan facility was availed from 2009 onwards. Now, my lords, this is a completely absurd conclusion for any logical person to arrive at, for the sole reason that merely because the loan facilities availed from 2009 would absolutely not imply that any and every activity done by the accused person is done through the proceeds of crime. Factually, it is not disputed that even this Gunwant Bhai is an agriculturist at the end of the day, and he owns agricultural lands. સાહેબ, ખેતીનું કામ, ખેતીનો ધંધો કરે છે, તો એમની પાસે કઈ કેશ ઇન્કમ તો ખેતીની જ આવવાની હતી ને. As again, I myself, they may, my lords, it is, my lords, I may only submit this way. 2010-11 ની પ્રોપર્ટી કેશમાં લીધી હતી, 2024માં માણસને પૂછે છે કે તમે 2010-11માં કેશ ક્યાંથી લાયા? તો my lords, it is humanly difficult for any person to remember the source of funds. I had already informed that these are agricultural activities, and my source of funds is my agricultural income. My lords, in the statement made by this accused at page 1914, question 13. Emma, my lords, the accused is giving the details of the properties he owns. Which are these properties?
Question number?
Question number 13, my lords, but 1 second, my lord. Sorry, my lords, there is... sorry, my lords. My lords, may have 718, question number 8.
Yes.
My lords, please furnish details of any immovable properties in your name. He has given the details of the properties. My lords, may see the sale deed value. 5.5 lakh, 7 lakh, 7 lakh. ત્રણેય પ્રોપર્ટી મળાઈને સાહેબ 19.5 લાખની થાય છે. સો ધ એલિગેશન ઇઝ નોટ ઇવન કે તમે વિલાસબેન પાસે જે 25 લાખ લીધા એમાંથી તમે પ્રોપર્ટી લીધી. આ પ્રોપર્ટીઝ લીધી છે 2010-11માં, વિલાસબેનનું ટ્રાન્ઝેક્શન તો 2012માં થયું છે. સો ધેરફોર the ED has no blanket power to assume facts, my lords. It is their responsibility and their duty to ascertain facts in the matter. Facts cannot be assumed, and a criminal liability imposed on an accused person basis assumption of facts. If I am saying that मैं ખેતીની activity કરતો તો હું ખેડૂત છું, એનાથી મેં આ જમીન લીધી છે, and it is not, my lords, if the allegation is of 58.6 crores, a person would not then not want to give details about 19.5 lakh worth of his own agricultural properties. These are all agricultural lands. They are not commercial or residential plots. 3 ખેડૂતાઈની જમીન જેમાં હું વાવું છું, મને મારું જે અનાજ વનાજ ઉગાડીને પૈસા વેચું છું, કમાઉં છું, એમાંથી હું કરું છું, મેં જમીન લીધી છે. My lord, they have to show that how are they coming to a conclusion that this is proceeds of crime merely because merely because the loan was availed in 2009. એવી રીતના તો my lord, even if I buy a 10 rupee dairy milk after availing a loan and tomorrow if something goes wrong, will that also be considered a proceed of crime for the shopkeeper? કે તમે 10 રૂપિયાની ડેરી મિલ્ક લીધી છે પણ તમે લોન 2010માં લીધી ને 11માં ડેરી મિલ્ક લીધી. My lord, in my humble submission, this by no stretch of imagination can be considered to be an offense under section 3 of the act. Owning agricultural lands. And my lords, this way there are, my lords, very sadly, but crores and crores of agriculturists and farmers in the country who would not be able to justify that from where they have purchased that cash land, because it is a small meager amount for all of them. So therefore, my lord, my submission is that again, he had no mens rea, no knowledge, and there are only two allegations against him. One is 25 lakh investment, one is the property. My lord's property I have answered by saying that there is no factual evidence placed on record by the prosecution to show that this is a proceed of crime. They are only assuming it is a proceed of crime. And secondly, with respect to 25 lakhs, my lords, first argument is I have no knowledge of the entire transaction. And even assuming if any, they have to show that how that 25 lakh itself is a proceed of crime.
Firstly, pointing out that how 25 lakhs is also a proceed of crime. It also finds mention in page 63 onwards, para 10.4.
Page
63, 64. 64 onwards I am reading. Firstly, on 21st of June 2012,
Page 64.
64 of the complaint. Amount in two tranches. Firstly, in 75 lakhs that gets transferred from the cash credit account of Champion Agro to the account of that is the separate transaction. Thereafter, from the same very account on 21st on that is on the very same day, another 25 lakhs gets transferred into the account of last land in two tranches. One in 20 lakhs and other in 25 lakhs. It is again from the last land that gets transferred to the parent applicant to one Kirabara. And from there it goes to charge account for execution of care. There it comes into thought that the original source of the fund from the fund which were being amount of that comes to the last land. From there it comes to get transferred or diverted to the amount of present applicant. And on the very same day, it gets transferred to charge account for execution. Yes, that is why it has been down as the source was again the loan amount. Second, sir, the piece of crime that has been attached for the present applicant are still more the property or whether outstanding amount or not. It has to stand as a value and that has been specifically mentioned in the attachment order, whereby the piece of crime was attached as a value because when the actual piece of crime is not available with the present, so the amount of the equivalent value gets attached. And this is why it has been attached as a value. Very specifically, that's data in the attachment order.
The statement is for rupees 25 lakhs. Right. For this section.
For this amount.
25 lakhs. Well, the only. Sorry.
And now the we can page number 7 on this portion number 5. Whereby we stated that I do not know about all these transactions. This is again criminal and shifting the burden again on the other two because I have no knowledge and I was doing it again on this person also. Because he is not a minor person again. He has been signing the account of the form, signing the check, and saying that I don't know the purpose of the transaction. That is not acceptable. All the stating that I do not know the purpose of the transaction, I simply sign it. That is shifting the burden on the other people so that they could come out of it. So actually stating that I have no idea about this, he is not minor person who has to be guided by some he was well aware of the transaction that is well. And again, in what is stated that I that is not acceptable and technical because yes, transfer of amount has been to that and you cannot say simply that I was not aware of the transaction. So clearly stating and simply giving no explanation as to whatsoever was the purpose, that cannot be taken off. That is
My lord, only two rebuttals I would like to make. Thus, first is my learned friend just mentioned that because no other properties were there, attachment order was passed. My lord, is my learned friend submitting that these are not proceeds of crime or the property is not purchased through proceeds of crime? Because the allegation made in the PMLA complaint is that because the source of funds is not there, we are assuming this is proceeds of crime. Because your loan facility was ongoing at that point of time. They may at least answer on what basis this assumption is made that this is proceed of crime. Their only answer is that oh પણ attached થઈ ગઈ છે. Attached તો થઈ ગઈ છે સાહેબ, એમાં અમે dispute નથી કરતા.
right for that. But falls within definition of section. And for that. Of crime, any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to its illusion or value of a property. So in this case, the value of the property has been attacked. It specifically covers within the definition of speak of crime in the section 2(1). So stating that it is not speak of crime, it is would be certainly falling within the definition. For example, that is the value and that is again certainly covered within the definition and
Well, the answer to that is the section reads or the value of any such property. My lords, it is not any property, any such property. What is such property, my lords? What is such? The property which is in respect of a commission of an offense or a crime. Therefore, my lords, the answer being that simply because આ તમારી આ property ની value છે ને આ time નું તમારું allegation છે transaction નું તો આ બી તમે ખોટા પૈસે દીધી છે, that my lords is not sustainable. And my lords, the only other rebuttal is that they consistently say that અમે કહીએ છે કે અમને knowledge નથી, that is not acceptable. Then at least prosecution may show that what the questions they have posed to the other accused to ascertain whether I am factually lying or not, or whether I am correct or not. That is the least responsibility burden which they have to discharge to show that all that to impute knowledge or to say that whatever I have stated in my statement is not correct. My lords, all the accused in their statement say consistently that accused number 2 and 3 ને બધું ખબર છે, અમને ખબર નથી. Consistently, my lords. Where have they shown in the statements or where have they posed the questions to them 2 and 3? કે આ વસ્તુ તમને જ ખબર છે કે બીજા બધાને ખબર છે કે નથી ખબર? 2 અને 3 બી એમના સ્ટેટમેન્ટમાં કહે છે કે અમને જ ખબર છે, અમે જ ડે ટુ ડે અફેર્સમાં ઇન્વોલ્વ હતા, બીજા લોકો કહે છે અમને ખબર નથી. તો they could have posed specific questions even for this allegation of 25 lakhs of ગુણવંત. They could have posed that question to 2 and 3 કે આ એમને ગુણવંતભાઈને નોલેજ હતી કે વિલાસબેનને નોલેજ હતી. because that responsibility and burden, in my respectful submission, they have to discharge because that could have at least thrown some more light on knowledge. But now that they have not done it at this stage, my lord, my submission is that there is absolutely no mens rea borne out from record.
Layers of transaction into 3 or 4 layers has been carried out, and that on the very next that means the transaction for the purpose of only diversion. That is.
Who remains?
Yes, my lords, 2 remains. My lords, may I continue that after recess or now as subject to my lord's convenience?
Now to the who remains?
Yes, my lords, only 2 remain, and in fact 50 or 60% of allegations are all already now covered. because they are all part of the allegations against the other accused persons. So those facts I will not, my lords, go into. I may just point out what the allegations are, but the allegations which I've already argued, I will not go into those details again, my lords.
Any more points to argue or?
My lords, there are only 2 or 3 allegations which are only for the main accused. Those I may have to argue, but my lord, I will try to finish it as soon as possible, my lords. Certainly, my lord, હમણાં તો recess પહેલા મારે એમે નહીં થાય.
Yes.
My lords, the my lords may turn to page 83 of the complaint. That's page 83, serial number 3, my lords. I'll start reading. Sitendra Kumar Gusabai Hirpara is the joint managing director of Measures Champion Agro Limited since 2003 to till date. He, along with other director, had obtained various loan facilities in the name of Champion Agro Limited, amounting to rupees 150 crores under multiple banking arrangements, wherein IDBI Bank had sanctioned rupees 55 crore loan credit facility. All applications for credit facility and further enhancement of credit were submitted by him along with other directors. Thus, he played a major role in fraudulent transactions performed by Measures Champion Agro Limited, which resulted in the loss of rupees 58.6 crores to IDBI Bank, Rajkot, and corresponding gain to himself. Second point, Sitendra Kumar Gusabai Hirpara was actively involved in purchasing agri inputs using bank loan funds and further selling of the agri produce to farmers without any collateral or security. He failed to deposit the sale proceeds amounting to rupees 222 crore approx in the designated cash credit/current account, which includes the outstanding amount of 58.6 crores of IDBI Bank. Jitendra Kumar Gusabai Hirpara. My lords, I may just now go allegation-wise allegation, so it would be faster, my lords. This 222 crore allegation, my lords, may find at page 27 of the complaint. Para 8.3.3. Page 27, my lords. The accused persons have admitted and stated that the sale proceeds of the agricultural input purchased from the loan funds given by banks, including IDBI Bank, were not deposited in the designated cash, credit, or current account. Due to this non-deposit of the sale proceeds, the account turned LPA. They have claimed that they failed to realize the sale proceeds from the farmers and customers to whom the sale of the agricultural inputs were made. Well, now here there is an inconsistency because ઉપરના પેરામાં એવું કહે છે કે સેલ પ્રોસીડ અકાઉન્ટમાં જમા નથી કર્યા, which would imply કે 222 કરોડ મળ્યા છે. નીચેના પેરામાં એવું કહે છે કે એ લોકોએ રિયલાઇઝ જ નથી કર્યા સેલ પ્રોસીડ ફ્રોમ ફાર્મર્સ and therefore અકાઉન્ટમાં જમા નથી થયા. There is a very big distinction between the two because the allegation, as I understand, is that 222 કરોડ જમા નથી થયા, but 222 crore એવું એલિગેશન જ નથી કે અમને મળ્યા છે, and we have not received that amount at all. Our in fact primary argument is that at that point of time in 2012, 13, 14 there was a major drought in Gujarat, because of which a lot of crops had died and farmers could not sell the crops અને બધું ખલાસ થઈ ગયું હતું. For that reason, whatever facilities we had given to farmers, they could not repay, neither could they produce or could they sell the farm produce to us. And that is the reason why we could not service the loan, and that is why the NPA happened. In fact, there was a multi-banking arrangement where 4 or 5 banks were involved. There were one-time settlement offers also, બધું થયું હતું, and out of all the banks, only IDBI, for their own reasons, has decided to proceed and file this complaint. No other bank has filed any complaint or initiated any proceeding against us. I may read further, my lords. They further claimed that the reason for such non-realization was drought into Gujarat in the year 2012 and 13, because of which value of agricultural inputs like seeds, fertilizers, pesticides, agri-equipment given to farmers on credit could not be recovered. The accused have admitted and stated that they do not have the specific particulars such as name, address, and contact numbers of the farmers/customers to whom the sales are made, and which allegedly failed to make payments against the purchase of the agricultural inputs. But this is factually incorrect, because statement માં કહે છે કે અમારી પાસે નામ છે, પણ વિગતો address ને એ બધી details અમારી પાસે એ બધી details available નથી. Because I'm given to understand that એ લોકોના જે agri farms હતા, જે 50 કે 52 stores હતા across Gujarat, all the details farmers used to physically go to the store there, and the data was maintained physically there. But because of the lapse of time, and because anyways of confiscation of all documents by CBI, we were not in a position to now take out this data from anywhere, because we are completely locked out. The main entity, the Champion Agro, is liquidation માં છે, so the liquidator is the one who has all the data and documents. બાકી એના સિવાય we as independent accused people have no access to the company record, and they may also show that where have they sought to collect this record from the liquidator. કે if I have made a statement કે આ બધું record છે પણ physical છે ને બધું ત્યાં agri stores માં છે, but since the company is under liquidation, some effort ought to have been made by the prosecution also to collect this record. But be that as it may, I may continue. They have further admitted that the sale of agricultural inputs, which were purchased with the loan funds provided by the banks, was made on credit to a large number of farmers without any collateral security of any kind. They further admitted that they have not taken any legal action against any of the farmers/customers who failed to make the payments against the purchase of agricultural inputs. Now, my lords, I may go to the statement given, that is Annexure G, page 361. (361). Hello, question number 2, if I may read from there. Please give the details of all the debtors of your company, Messrs. Champion Agro Limited, CAL, as undertaken by you in your previous statement dated so and so. I state that rupees 222 crores odd amount has remained pending for payment against approximately 30,000 farmers who availed/taken services and agri inputs from my company, Champion Agro Limited, on credit. They all did not pay their dues to my company, citing the reason of crop failure due to drought. Only name and amount of dues against them are available with me. I do not have other details like address, contact details, and any documents which supports the above claim of outstanding amount. I will provide the details of so and so of approximately 50 farmers on so and so. On being asked, I state that both the Kharif and Rabi crop failed due to drought in 2012. That is the period from June 12 to March 13 in the whole area where my company Champion Agro Limited was doing business. Then the next question. I may just read the answers, my lord. Yes, bill invoices were issued against all supply of agri inputs made to the farmers, but I do not have any documents/data with me because this has all been confiscated. And then, my lord, question number 6. What services were provided by your company through agro malls to the farmers? My company, Champion Agro Limited, used to provide agri inputs like seeds, fertilizers, pesticide, agro equipments, and cattle feed to the farmers. My company also used to purchase agri produce from the farmers. My company used to supply agri inputs to facilitate the cultivation of cotton, groundnut, wheat, maize, gram, castor, and different vegetables and produce of the same was also purchased by our company. Therefore, the entire business of the company was કે હું તમને આ ક્રોપ્સ ઉગાડવા માટે બી પ્રોડક્ટ્સ આપીશ ને એ બી તમે મારી પાસેથી લોન પર લઈ શકો છો અને તમારા પ્રોડક્ટ્સ થઈ જાય એકવાર વીટ ને બધું અનાજ ઉગી જાય પછી એ બી તમે મને વેચી શકો છો. Now because of drought they could not service the loan and they could not give the crops back. That is the reason why I am saying that I have not realized 222 crores. I am not saying that I have received that amount and neither have they do not have any iota of evidence or document also to show કે મને 222 કરોડનો નફો થયો છે. Their allegation is that 222 કરોડ તમને રિસીવેબલ્સ હતા જે રિસીવ નથી થયા ને એના લીધે તમારું એનપીએ થયું છે. Because by no stretch of imagination can this be considered to be a criminal offense. At best it may be a very bad turn of business that I could not service the loan and this is the reason that I could not get the money from people whom I was owed the money to. But they are now connecting it to say that you are not able to produce or give any documents to substantiate your argument. Whereas again, I would only say that after 12 years, if I am asked to substantiate events which have happened 12 years ago, especially when multiple proceedings have arisen, I am locked out from my company. I do not have access to the data or records. Whatever I have, I've already provided. And they, being the investigating authority, have all the power and power to find documents, to call for documents from other people. But they have not put this effort to find out all of these documents or whether my actual averments are actually correct or wrong. Therefore, my lords, my argument and my submission for this allegation is that 222 crores was because of genuine business difficulty and business reasons that could not be received by me. And there is no proceeds of crime or there is no criminal activity done by me in respect of this 222 crore rupees allegation. My lords, now we go to the second allegation. Jitendra Kumar, I am continuing, my lord, at page 83 again. I am reading point number 3. Jitendra Kumar Kusabai Hirpara was involved in fraudulently diversion of bank loan fund for settlement / repayment of loan and interest liability of other sister concern, that is Champion Agro Finance Limited, to the tune of at least 2.12 crore. My lords, this is the same allegation, 1.32 crore plus that 80 lakhs, which was already an allegation against Champion Finance. My lords, my only answer to this and what I would like to submit is that this, in my statement, I have admitted that this has been done, that this loan servicing has been done. Therefore, my lords, for this allegation, I would only submit that as such, it is not a criminal activity because I have not personally benefited from this transaction. At best, if it is a civil wrong and not money laundering falling under the scope of Section 3 of PMLA. That was now point number 4. Jitendra Kumar Gusabai Hirpara, through a series of transactions and using multiple savings and current accounts of his relatives, deliberately diverted rupees 1.2 crore from bank loan funds for purchase of 12 lakh shares of Champion Finzec Limited. Now, my lords, this is the same allegation as of Vilas Ben, which is accused number 7. The first discharge which I had argued, કે 1.2 crore એમના ખાતામાંથી 20 લાખ રૂપિયા એમને shares ના લીધા, બીજા કરોડ રૂપિયા લીધા. Therefore, my lords, again, the answer to this is that the money given to Vilas Ben or this 1.2 crore was in respect of the produce she had supplied to the company. And therefore, from her money, this loan has been serviced. Therefore, as such, there is no question of applicability of Section 3 of PML. Then, my lords, I may go to point 5. Jitendra Kumar Gusabai Hirpara has complete knowledge of diversion of the bank loan funds towards personal savings account of his brother Dheerajlal Gusabai Hirpara in purchase of property. Further, he also involved in purchase of other properties using bank credit facilities to the tune of at least rupees 42 lakhs in Gurgaon, Haryana, which were later used to settle unsecured loans availed by himself. Now that this allegation is, my lords, may have page 31 of the complaint. Page 31, para 8.3.9.
Para
8.3.9. Let me read. Facts related to diversion of rupees 41.99 lakh from CC account number so and so of Champion Agro Limited maintained in IDBI Bank to invest in property. The accused have admitted and stated that in the year 2012, they used funds from CC account number so and so maintained in IDBI Bank to get allotted 6 commercial office spaces in the name of Messrs Champion Agro Limited from VSR Infratech Private Limited without approval of lender banks against the terms and conditions of loan facility. The accused have stated in their further statements that they surrendered 4 units back to VSR Infratech and remaining 2 units were transferred in the name of Bhushan C. Sardar C. Solanki. Analysis/findings. As per statement of accused, in November 2016, Bhushan C. Sardar C. Solanki lent unsecured loan of 1.5 crore to Jitendra Gusabai Hirpara in cash only, but he was not able to return the amount as their business was going through huge financial crisis. Thus, in 2020, they transferred the above mentioned 2 commercial office spaces, which was purchased by using loan funds availed from bank in the name of Bhushan C. Sardar C. Solanki to settle the unsecured loan worth rupees 1.5 crore. These facts has been admitted by accused persons, that is Dheeraj Gusapar and Jitendra Gusabai Hirpara, in the statement dated so and so. Now I may lords only go to the statement before the ED, that is Annexure G. I will just tell my note. Page 448.
Yes.
My lords, question 5 at page 448. Please state whether funds from CC account number so and so maintained by the IDBI Bank were used to purchase 6 plots in 114 Avenue, Gurgaon, Haryana. It is correct that the funds from CC account number so and so maintained at so and so were used for allotment of 6 plots in 114 Avenue in the name of Champion Agro Limited. Rupees 41.99 lakh were transferred from CC account number so and so maintained at IDBI Bank to current account number so and so maintained at Union Bank of India, Gurgaon. On being asked if I further state that total rupees 75,49,072 was paid to Messrs VSR Infratech Private Limited by Champion Agro Limited in the year of 2012 for the allotment of 6 plots mentioned above, wherein amount other than above rupees 41.99 lakh was paid from current account of Champion Agro Limited. I further state that I do not remember the bank account used for the transaction of a payment other than the payment from cash credit account maintained at IDBI Bank, Rajkot. This is the state. Then I may go to the next allegation. Point number 6 at page 84 of the complaint. Jitendra Kumar Gusabai Hirpara, through a series of transactions by means of huge cash withdrawals and using his and his brothers Dheeraj Gusabai Hirpara current accounts, knowingly diverted the bank loan funds to the tune of at least 1.85 crore for taking over Messrs Champion Finsec Limited by purchasing convertible bonds in his name and later on converting the same into equity share in his name and in the name of his family members in connivance with his brother Jitendra Kumar Hirpara. For this, my lords, may turn to page 28 of the complaint, para 8.3.5. My lords, this contains the entire allegation and the statement with respect to this is made before the ED. That is at page 5088, answer to question number 2. My lords, As such, they have stated that this transfer was done. So I am not reading the entire answer. I am just giving the reference of the answer to my lords. Then, my lords, the next allegation, which is allegation number 7 at page 84. May I read, my lords? Jitendra Kumar Pusabai Hirpara was actively involved in acquisition of Messrs. Home Fresh Fruits Private Limited using bank loan funds availed from IDBI Bank Limited Rajkot and appointment of employees of Champion Agro Limited, relatives and friends as directors of Home Fresh Fruits Private Limited. Now, my lords, this my lords will find at page 33, para 8.3.10. I may read from 8.3.10a. Viradlal Hirpara in a statement dated so and so admitted and stated that he acquired Home Fresh Fruits Limited in 2010-11 with all its assets and liabilities. For this acquisition, a total of rupees 1 crore was transferred in the bank account of Home Fresh Fruits Private Limited. This includes transfer of rupees 29,25,000 from cash credit account of Champion Agro Limited bearing number so and so maintained in IDBI Bank, and the remaining amount was transferred from cash credit bearing account number so and so maintained in Axis Bank. He further stated that he required Home Fresh Fruits Private Limited acquired it with an outstanding of approximately 3-4 crore term loan availed by Home Fresh Fruits Private Limited. Then they go on to talk about the shareholding. And the last paragraph says that directorships are offered to friends and family members. Now, was the in the statement the accused at page 336, question 1, answer to question 1, annexure F. Page 336. My lord, the answer to question number 1, as such, the accused has mentioned that how the transfer and all was happened. But my lords, what is relevant is if my lords may see page 337, the second para from top, which starts with I and my wife Srimati Geeta Ben Hirpara. Am I with my lords? I and my wife Srimati Geeta Ben Hirpara are shareholders of approximately 35% and 30% shares of Home Fresh Fruits Private Limited respectively. Further, remaining shares, that is 7.21%, were given by me to Kantilal N. Tarpara, who was employed in Champion Agro Limited, and 27% shares were given by me to my nephew Jaideep Jaisukbhai Kakadia without any consideration amount and only on paper. Thus, actual beneficial owner of the above shares are my brother Jitendra Kumar Hirpara and myself. Then my lord may go to the, then I will just read the next two paragraphs because they are also, my lord, extremely relevant. Further, Srimati Geeta Ben D. Hirpara, Shri Kantilal N. Tarpara and Shri Jaideep Jaisukbhai Kakadia only signed the documents of acquisition of shares on my instruction. In this way, entire shareholding of Messrs. Home Fresh Fruits Private Limited is with me and I and my brother are the beneficial owner of entire shareholding, as we are the promoters of so and so. Further, I state that I offer directorship of Home Fresh Fruits Private Limited to 4 of my employees in Champion Agro, namely Birju Tarpara, Kantilal Tarpara, Sachin Walani, and Hasmukh Thumar, and my nephew Jagdish Jaisukbhai Kakadia, which they accepted and became directors. However, they were directors on paper only. All day-to-day activities and transactions of so and so were whole and solely managed by me and my brother, and we have effective control over Home Fresh Foods Private Limited. Now, let's going just a slight detour from this, going back to my earlier argument for Kanti bhai. My lords, in the statement, my lords may see that બીજા shareholder છે, આમને જ બીજા લોકોને shareholding આપ્યું છે. છતાં બી, and more the accused says that I am the ultimate beneficial holder, everything is done by me, and ultimately they are only signatories on paper. Then my lords, I may go to the next allegation. That is, my lords, at page 85, allegation number 8. Jitendra Kumar Gusabai Hirpara has influenced and incited his wife Srimati Vilasben Hirpara to use her bank account to commit routing of the proceeds of crime received from the banks as loan amount, hence has used it for his family's and personal benefits. This is the only allegation. As such, the only argument is that my wife was unaware of everything, and if they are ultimately at one place saying that I have incited my wife, ને હું beneficial owner છું, તો એનો accuse થવાનો ક્યાં question આવ્યો? અગર મારા incitement પર ને હું beneficial owner હોઉં તો. Therefore, they cannot ride on two boats at the same time. Then my lords, point 9. Jitendra Kumar Gusabai Hirpara, along with his brother, deliberately siphoned off bank loan funds through huge cash withdrawals during 2009 to 2013, specifically rupees 12.62 crore in financial year 12-13, when Champion Agro Limited was going to financial crisis for personal consumption or for unrelated purpose. As no convincing explanation has been given by accused that the funds were used for business-related purpose, it is sufficient to conclude that the funds were withdrawn in cash has been siphoned off. Now, my lords, my answer to this I have given in my statement, my lords, at Annexure G, page 397. Am I with my lord? Page 397, question 20. It is noticed that the following year-wise cash withdrawal was made from loan bank account bearing number so and so of Champion Agro Limited, maintained in IDBI Bank Limited. The total is 15.67 crores. Answer. I state that as far as I remember, most of the cash withdrawal were made for payment to farmers to purchase the agricultural produce. Presently, I do not have any specific details or documents to support the same. And this is the answer. And the only supplementary fact I would like to add is that because of the elapse of time, I do not have these documents available as on date or when the statement was taken in 2024. Then, my lords, the last allegation against me, which is Jitendra Kumar Gusabai Hirpara was also involved in disposal of movable hypothecated properties worth rupees 2.2 lakhs during financial year 14-15 without prior permission of IDBI Bank Limited, which was holding first charge over entire fixed assets of Champion Agro Limited, and further the sale proceeds obtained thus were placed in HDFC Bank, which was not a part of multiple banking arrangement system, which is a gross violation of terms and conditions of bank loan facility. Although, as such, my lords, in the statement, I'll just give my reference. As such, the statement says that this has happened, but the only argument I would like to make is that that this would not fall under the ambit of Section 3, because as such, the money I have not personally benefited from the amount. It is ultimately transferred to another bank for servicing of a loan, for which other civil remedies are available. This is with respect to Jitendra Kumar Hirpara. Now, only the last accused, which is Dheeraj Lal Hirpara. Yes, my lords. My lords, there are only two or three allegations which are different, but not more. I may just then directly take my lords through that, or very well, only through those, my lords. My lord, that specific role starts from page 79 of the complaint. Maharaj, I will just quickly run through the points. First point is a general allegation. Point number 2 is the allegation with respect to 222 crores cash, which I am saying that I have not received it at all. Then point number 3 is with respect to again that to transfer of amount to Champion Agro Finance of 2.12 crores. And that's point 3 at page 80. At the top of the page. Point 3 is with respect to that 2.12 crore amount, which is already answered by in for Champion Agro Finance Limited. Then point 4, it with respect to purchase of shares of 1.2 crores. This is the same allegation as Vilas Ben's allegation, which is already answered. Then, my lords, point number 5 after that. Dheeraj Lal Gusabai Hirpara fraudulently diverted the bank loan funds to the tune of at least rupees 1 crore towards his personal savings account to purchase property in his name. Further, other properties in Gurgaon, Haryana were purchased using bank credit facilities, which were later used to settle unsecured loans availed by his brother so-and-so, joint managing director of so-and-so. My lords, I will only give the reference of the statement made in this in respect of this allegation. That is Annexure F, page 311, answers to questions 2 and 3. Annexure F. I am not reading the statement, I am just giving the reference for ease of page 311, Annexure F, question numbers 2 and 3.
Yes.
Then I may just move on to the next allegation. That is point number 6. This is with respect to the allegation of 1.85 crores by purchasing bonds of This is my lords with respect to Champion FinSec. कि एमना 1.85 crores through other family member shares खरीद लिया था. Now, my lords, the answer, this is also, my lords, forms a part of the earlier allegations. So I am not running through this also. Then point number 7. This is the allegation of the cash amount, which is 12.62 crores. They हमें withdraw karya tha, which I just referred to in the previous discharge application. So this is also a common point. Then, my lords, point 7, point 8 is with respect to that 2.2 lakhs property. The fixed, the movable asset which was sold. Point 9 is with respect to Home Fresh Fruits. Only, my lords, there is one other point. My lords, we only have point my lords, point 11 and at page 82. Accused Dheeraj Lal Gusabai Hirpara also purchased the land property in the name of a person, namely Shri Mansukh Vasovia, in cash only, and later got this property transferred in the name of his son and deliberately hid this transaction during his statement. He further could not even explain the source of funds during his statement. Now, my lord, this is something which forms a part of the statement, but the only point I would try to make here is that આમાં બી સાહેબ એવું છે કે બીજા કોઈના પાસેથી એલિગેશન ઇસ કે તમે કોઈને કેશ આપ્યા, તમારા છોકરાના નામમાં પ્રોપર્ટી લીધી અને પછી અલ્ટિમેટલી તમે બેનિફિશિયલ ઓનર છો. But none of these people are made as an accused. So therefore, my lords, with respect to accused numbers 4 to 7, to conclude, my lords, the argument for Dheeraj Lal Hirpara, my lords, these are the only allegations against him. So I am not dealing with them individually again. Otherwise, my lords, I would only like to submit that with respect to accused numbers 4 to 7, there is cherry picking done by the prosecution to ensure that whichever accused they feel would hurt me the most are made as an accused in the PMLA matter. Because neither of the ingredients of section 3 of PMLA are met with respect to them. And there is absolutely no mens rea, which is borne out from the record and from the statements.
The nature of allegation would against both the accused would commence from page number 55 onwards, with respect to all the diversion of proceeds of crime. I would be reading the relevant portions of their statement to point out their for accused number two, sir. Firstly, he has in total diverted the first allegation would stand for the diversion of 87 lakhs from IDBI to purchase the property. In this is again the relevant dates would be relevant because the transactions are carried out in a span of 1 or 2 days to for transfer of amount from the cash credit account of Champion Agro to the account of the accused number 2, and then it was transferred to Precision Technology for purchase of a land. And again, the land was purchased in the name of the applicant, accused number 2, that is the applicant herein. So the argument that he has not been benefited from the diverted amount, or no such property has been purchased, or there is no such benefit to him, that stands negated because he has purchased the amount and purchased the property in his own name by diverting the loan amount. And again, the argument that diversion of loan amount is not a criminal wrong, that does not stand because the amount, terms and conditions for which the loan was sanctioned, and they are willfully stating that yes, this was against the, and it was in their very specific knowledge that these are not the terms and conditions for which the loan was granted. That cannot be taken into account. The diversion itself comes under the ambit of section 3.
Malad, sorry to interrupt, but my argument is not a blanket argument that any kind of diversion of funds is not a criminal activity. I am saying that when it is used for facilitating other loan, etc., where I have not benefited from it, it is not. Rightly or wrongly, it may be separate, but it is not my blanket argument that any diversion is not a criminal activity.
Right. But here the benefit also stands accrued to him because he has been diverting the amount, purchasing property in his own name. That is my first submission. So, page number 340 of the RUD. Answer number 3 would be relevant. I would be reading the question for the girl. Do you understand that your company, Champion Agro, violated terms and conditions as described in below, and subsequently in the enhancement of loan facility sanction letter so and so date? His answer would be relevant because yes, it is correct that I, chairman and managing director of the Champion Agro Limited, and my brother, as joint managing, violated the above terms and conditions described in all sanction letters issued by IDBI Rajkot for availing the loan facilities of Champion. Their relevant because their knowledge would here again be there because they are stating that we know that these were against the terms and conditions of the loan, but still they have indulged into such activities. Again, 10.2 at page number 57 would be relevant for the fact that again the dates of again would be this on the very same date. Cash is withdrawn through 2 checks to the tune of 42.5 lakh each, and it gets deposited into the account of accused number 2 and accused number 3 on the very same date. And then the amount of rupees 50 lakhs again gets transferred from the account of accused number 2, which was again received through the loan amount, and it was diverted to Montana Securities for purchasing the convertible bond. 37 lakhs convertible bonds were purchased, and that was again converted into equity shares, which again later turned into the Champion Agro FinSec Limited. That Montana Securities turned into Champion Agro FinSec Limited, and that initial amount of 42.9 and 42.5 that turns out to be 85 lakhs. That was diverted and again used to purchase the equity shares of some other company. And again, the benefit has accrued to the present applicant and as well as accused number 3. Then at page number 61, the diversion of 1 crore of the amount that was taken from the loan amount was has been depicted, whereby 50 lakhs each has been deposited into the account of accused number 2 and 3. Then again, it was again misutilized, I would say, for the purchasing of or repayment of the loan of ILFS, which is again not the purpose for which the loan was sanctioned. For allegation 10.4, I have already dealt with in the previous because it has been initial amount diverted from the fund for into the account of accused number 2 and 3, and thereafter in the subsequent to the accused number 5 and 6. Then again, there is a cash withdrawal from the account of the loan amount, which turns out to be around 15.95 lakh, for which no such cash book has been given on record or to procure or to give any explanation as to for what purpose the cash was withdrawn by them to the tune of 15 crore. That accounts the considerable amount of the total amount of POC, that is 56 lakh. So 15 crore they have already taken in cash and misutilized. So saying it that it was a natural calamity, I would certainly not accept it, and certainly there is no explanation coming on God, and burden under section 24 is on them. They cannot claim that prosecution has to give an explanation to that. It is their cash withdrawal. They have to come up with their explanation for what purpose this cash was withdrawn by them. Certainly saying it merely it was a natural calamity or drought was there, certainly it is not tenable. It is from the transaction which were diversion of crores of rupees on a very single day. That is certainly not a natural but a man-made calamity, I would certainly say that. Then at 10.8, page number 74 would be relevant of the prosecution complaint, whereby around 1 crore were diverted by the present applicant for purchase of the company Home Fresh, and it is again they admitted that it is not for the purpose for which the loan amount was sanctioned. I would be reading the relevant statement of accused number 3. At page number 447, question number 447 onwards, question number 3 to question number 11 would be relevant for this. Page 447, question number 3. Please state whether the funds of CC accounts were used towards the repayment of a loan facility. Yes, they have agreed to it. I would be straightly coming to answer to question number 10 at page number 451. Question number 10. Why was the cash credit facility from IDBI Bank Rajkot availed by Champion Agro used to purchase the share of group company Champion Agro Limited and Champion Finsec Limited? The cash credit facility by IDBI Bank was availed as working capital for Champion Agro Limited. However, the funds of the cash credit facility availed from the IDBI Bank were used to purchase the share of group company of Champion Agro, that is Champion Finsec Limited, against the terms and conditions of the cash credit facility availed from it. So considering all these statements and their own admission that it is again the very facility which was sanctioned by the bank, it certainly is that a grave suspicion is there to frame the charges against the accused, and claiming that it is merely a civil wrong, that is not tenable, and then every accused would divert the amount, take the procedure of crime, purchase one property and state that it is a civil wrong. I may be exonerated from the criminal liability. So that is again against the very nature and the purpose of section 3 of the Money Laundering Act, and considering section 2 and U of the Proceeds of Crime, section 24 burden of proof, then certainly the present application be kindly. I would be making submitting the relevant RUD files, which would be relevant for each accused. A note on it.
Give the date.
Immensely obliged for the patient hearing. My lord. Deeply grateful. My lords my lords that imposed that cost of 10,000. My lords, may kindly grant me 2 or 3 days. I will get it done, my lords.
Against me. So it is, as it is called an anti-suit injunction. There are two judgments of the Honorable Supreme Court which support my case. The injunction has been refused on the ground, 3 grounds. The lower court, I'm sorry, refused the ad interim injunction. On one, saying that there is some delay. After I received the summons from the the Paraguay court, I have not approached the court promptly. That's one reason. Second is that I have not produced the entire record of the Paraguay suit. Hence, the court is not able to decide the issues involved in the suit in Paraguay. And thirdly, that I have not been able to show that the Paraguay court does not have jurisdiction and only this court has jurisdiction. These are the 3 grounds on which the lower court has refused ad interim injunction. Now, I will satisfy Lordship that all these 3 grounds are not sustainable in law, and I, in fact, deserve an ad interim ex parte injunction. That is what my case is. Now, I may just give a few facts. There was an agreement entered into between the 23/12/2015. First agreement entered into between the plaintiff before my lords and the defendant, which is a Paraguay-based company.
पेपर खाली प्रोडक्शन किया पेपर का नीचे ना
This in 2015.
Yes, it is 23/12/2015. In that agreement, there is a clause which appoints the defendant as the sole distributor in Paraguay, clause 2.1. And there is also a clause 21, which provides for governing laws and jurisdiction. My lords, I've just passed over a compilation. If my lords can please have a look at that compilation. It's a list of it's a plaint and the list of documents. If my lords have the list of documents, at page number 1 is the agreement 23/12/2015.
Where are you?
I'm sorry.
Page 1 is the memorandum of claim.
Yes, after the plaint, lordship, there's a list of documents.
Yeah.
And the list again starts from page 1 to page 1 onwards. The documents start from page 1 onwards after the list. The list ends at page 22, I think.
Yeah.
Yes, and thereafter the documents are there. So page 23 is the document, the first agreement, 23/12/2015. My lords may have a look at page 3, para 2, clause 2.1. My lords have got that? It's in 2 languages. On left hand side is the English language.
Yeah.
Based on the representations made herein above by Euroquimica, Equilife hereby appoints. Equilife is the plaintiff. Euroquimica is the defendant, as its sole and exclusive distributor for the products specified in Annexure 1. That's all that my lords need to see at this minute. Thereafter, my lords may please come to clause 21, which my lords will find at page 24. Left hand side bottom. Governing laws and jurisdiction. In the event of any dispute or difference between the parties relating to, touching, or in connection with this agreement, both parties shall make an effort to resolve all disputes, differences, or disagreements through discussions at the highest level. 21.2. However, if any dispute or difference cannot be resolved by mutual discussion, the same will be finally, my lords may please note the words, and exclusively decided by the court of appropriate jurisdiction. My lords will have to go to page 25. Based in Ahmedabad, India, and laws of India shall accordingly govern such proceedings. The proceeding shall be conducted in English. This agreement, Lordship, of 23/12/2015 was for a period of 3 years, expired on 23/12/2018, but parties continued to do business between the two of them under this first agreement, and thereafter the second agreement is executed, which is the agreement in question at page 36. At page 37, clause 2.1. Based on the representation made herein above by distributor, Aculife hereby appoints distributor as its exclusive distributor for the products as mentioned in Annexure 1, etc. So same clause 2.1 continues. Thereafter, my lords, may please come to clause 21, which is at page 50. Unlike the first agreement, clause 21 here has 3 sub-clauses. Clause 21.1 is an addition. My lords, have got page 50. This agreement shall be construed according to the laws of India. In the event of any dispute or difference between the parties relating to, touching, or in connection with this agreement, both parties shall make an effort to resolve all dispute, differences, or disagreements through discussions at the highest level. 21.3 important. However, if any dispute or difference cannot be resolved by mutual discussion, the same will be finally and exclusively decided by the court of appropriate jurisdiction based in Ahmedabad, India, and laws of India shall accordingly govern such proceedings. The proceedings shall be conducted in English. This agreement was also for a period of 3 years. Now, during the subsistence of this agreement, around November, December 2023, pages 61 to 63, we proposed an amendment in the agreement by emails, which emails my lords will find at pages 61, 62, 63. We sent the proposed amendment. They read the amendment, they signed it, and they sent it back. The amendment is at page 64. At page 64 at the bottom, if my lords can please have a look. Now, this amendment agreement witness as follows. My lords have got that? Page 64.
This is amendment to the 21 agreement.
Amendment to the agreement of 2021. I am obliged. This was sent by emails, which are at pages 61, 62, 63. Now at page 64 at the bottom, clause 2.1, right at the bottom. Based on the representations made herein above by distributor, Aculife hereby appoints distributor as its, my lords may please note, as its distributor for the products as mentioned. So the word exclusive now goes away. Original 2.1 had the word exclusive, which my lords can have a comparison at page 37. So this was one change. The other change was with reference to certain products, additions and deletions of products as per the annexure to the agreement. Sometime in December 2023, after the amendment in the same month, the plaintiff appointed another distributor in Paraguay. Thereafter, some emails are exchanged because when the defendant learns that we have appointed another distributor in Paraguay, they address certain emails, which my lords will find from pages 75 to 79, making a grievance that we have misrepresented them and we have kind of falsely reduced them from exclusive distributor to only distributor. We had given the draft amendment by an email. They read the draft amendment, they signed it, they returned it back by email. Those emails are at pages 65 onwards. And then I refer to the draft agreement, which was signed. Now they say that we misrepresented and by reducing them to only distributor from exclusive to one of the distributors. So this is the email which comes from their lawyer. These emails are 26/4/2024 and 1/5/2024.
Amendment agreement was,
Sent by email. I'll just point out those emails. My lord may see pages 61, 62, 63. 61 first. My lord, page 61.
yes,
It's an email from us, Anuj Kumar Rai, so and so at AccuLife, that is a plaintiff. As we have added some new products in our portfolio, our legal team has proposed to sign an amendment agreement. Kindly review and provide your confirmation to sign the agreement by next week. Then my lords may turn over a page. Please find attached the signed agreement copy. Then at the bottom, at the second half of that very page, December 1, 2023, at page 62, second half of the page, from Marcelo Rienzi. My lords have got. My lords have got the words bold, AccuLife Healthcare on page 62. 62. AccuLife ni pachi છે સાહેબ from Marcelo Rienzi. સર અહીંયા સર આમ વચ્ચે છે AccuLife છે ને એની પછી છે આ તરત જ પેલું ઈમેલમાં આવે ને from and to. હા from છે ને સર એ from Marcelo Rienzi at Euroquimica. Euroquimica is the defendant. Sent Friday so and so to Anuj Rai. Anuj at AccuLife, subject amendment agreement. Dear Anuj, please find attached the agreement signed. મળી સાહેબ આપને એટલે એ લોકોએ અમે એમને મોકલ્યું ડ્રાફ્ટ મોકલ્યો એમને સહી કરીને અમને પાછું મોકલ્યું અને that agreement was then acted upon. After 3-4 months, their advocates sent emails, which is why at page 75 to 79, saying that we have misrepresented in getting the draft amendment signed by them, which is at page 75. I don't need to trouble my lords by reading those emails at this stage. Thereafter, negotiations and meetings take place between the plaintiff and the defendants, and video calls have also take place. These are the pleadings in the plaint. The defendant again addresses an email at page 82. My lords can have a look at page 82 just to see that it's an email from defendant to the plaintiff, again making the same allegations. After this, we reply at pages 80 to 81. This email is 13th June. Our reply is pages 80-81, 20th June. Right at the top, the date is mentioned. In this background, the defendant files a suit in Paraguay court in South America against me, claiming compensation that they have suffered a loss by us appointing somebody else also as a distributor. Defendant was originally meant to be only the sole and exclusive distributor, but we now have appointed other distributor. We have committed breach of the agreement, etc. And so they filed proceedings in Paraguay, claiming compensation against us on the basis of this very agreement. Now this, my lords, will find at page 97. And if my lords can please see page 97 and from page 98 at the top. Page 97 at the top is translation, Supreme Court of Justice, Judicial Revenue, Settlement of Legal Cases, etc., etc. Euroquimica Plaintiff, AccuLife Healthcare. I'm on page 97. Thereafter, page 98 at the top, my lords will just only note page 1 of 21. It goes on right up to page, several pages thereafter, up to page 120, 133, up to page 133. These are the proceedings filed by them against us. This is filed in 21/11/2024. Then my lords may please have a look at page 95.
It is filed on
21/11/2024, which my lords may find the date. My lords can just, yes, page 97. It is also numbered blank of 2020, is also of the year 2024.
yes.
Date of settlement, etc. Then my lords may please have a look at page 95. This is letter rogatory. Letter rogatory, lordship, is a letter of request issued by one court to another court in foreign jurisdiction, inter alia, for the purpose of effecting service of summons on a company or an individual in that foreign jurisdiction. So this is that letter. My lords can just, I don't need to read the entire letter. It's a letter dated 24/2/2025. I, the undersigned, judge of the first instance on civil and commercial matters of the 13th Circuit, Luz so and so, with seat in the city of Asuncion, capital city of the Republic of Paraguay, to the honorable judge of the same class and jurisdiction in the city of Ahmedabad, do hereby greet, request, and make known that before this court secretariat under responsibility so and so, lawsuit number 413 of 2024. My lords have got that second line. That before this court, yes. So it's a filing of 2024 entitled Euroquimica, that is the defendant before my lords, Equilife plaintiff before my lords, on compensation for damages, is being processed, in which the following letter rogatory is issued in order to request to serve a copy of the lawsuit to the defendant Equilife with his registered address at Commerce House, etc., etc., etc. Now this letter rogatory, which is dated 24 February 2025, appears to have been received in the Embassy of Republic of Paraguay sometime on 6 August 2025, which is at page 94. And that appears to have been given to the Ministry of External Affairs at page 93. I am just trying to show how the summons traveled from Paraguay to India, etc. Page 93 is the office memorandum, Ministry of External Affairs, for the purpose of service. Thereafter, my lords may see page 92, which is important. It's a letter of request from Government of India, Department of Legal Affairs, addressed to this honorable court, because it's the jurisdiction of this honorable court, essentially for the purpose of service, and it was inverted into this honorable court on 16th September, right at the bottom right, page 92, bottom right. You know, Sikko che seva court no. Now, after this, we received it on 8/10/2025. 8/10/2025, which is a factor which has weighed with the lower court for refusing the ad interim injunction. Because the lower court is of the opinion that I received on 8/10. I have filed the suit in April 2026, roughly 6 months thereafter. There is no explanation. There is a delay. I don't deserve an ex parte order. That's the whole reasoning of the lower court. Now, this is the background. Now, in this background, I filed the suit. And if my lords can have a look at the prayers in the suit, and then I'll take my lords to the prayers in the injunction application. My lords have got the plaint. Plaint page 16.
Yes.
This honorable court, my lords have got that. This honorable court be pleased to hold and declare that the plaintiff is not liable for any payment to the defendant in respect of agreement as amended by agreement dated 1/12/23. Honorable court be further pleased to hold and declare that the defendant has no right to institute suit 413 of 24 against the plaintiff in the courts of Asuncion, Paraguay under the agreement dated 25/10/21 amended by amendment agreement 1/12/23. Honorable court be pleased to hold and declare that the defendant by instituting suit 413 before the courts at Asuncion, Paraguay is in breach of the agreement dated so-and-so as amended by amendment agreement dated so-and-so. This honorable court be pleased to issue mandatory injunction against the defendant, restraining it from proceeding against the plaintiff in civil suit number so-and-so, etc. Along with the suit, I have produced these documents which I have just referred to, and I also prefer an application exhibit 5, exhibit 7, which my lords will find immediately in the appeal compilation. Appeal compilation, there is a list of documents and that contains my application exhibit 7. It's a detailed application, but the prayers are at page 17. This, my lords have got that? Yes. This honorable court be pleased to issue temporary injunction against the defendant, restraining the defendant from continuing suit 413 of 24 before the courts at Asuncion, Paraguay. B. This honorable court be pleased to issue ex parte ad interim relief in terms of para 32A. So this is what is refused. And that is how I am before my lords. Now, before I go to the impugned judgment, if I can just request my lords to have a look at two judgments of the Honorable Supreme Court on anti-suit injunction. The first judgment I may request my lords to take up 2003-4 SCC 341 Modi Entertainment Network. In that, my lords I can request my lords to turn to paragraph 10. Paragraph 10, my lords will find internal page 11.
Yes.
My lords have paragraph 10. Yes. The courts in India, like the courts in England, are courts of both law and equity. The principles governing grant of injunction and equitable relief by a court will also govern grant of anti-suit injunction, which is but a specie of injunction. When a court restrains a party to a suit proceeding before it from instituting or prosecuting a case in another court, including a foreign court, it is called anti-suit injunction. It is a common ground that the courts in India have power to issue anti-suit injunction to a party over whom it has a personal jurisdiction in an appropriate case. This is because courts of equity exercise jurisdiction in personam. However, having regard to the rule of comity, this power will be exercised sparingly because such an injunction, though directed against a person, in effect causes interference in the exercise of jurisdiction by another court. My lords may now turn to para 24, which are the governing principles. From the above discussion, the following principles emerge. In exercising discretion to grant anti-suit injunction, the court must be satisfied of the following aspects. The defendant against whom injunction is sought is amenable to the personal jurisdiction of the court. For this purpose, Lordship, I rely upon those clauses in the agreement where the parties have agreed that this court will have exclusive jurisdiction and the agreement will be construed by the laws of India. Those, so clause 21. So they have subjected themselves to the jurisdiction of this court, and hence this court has jurisdiction over the defendant. The very first condition which the Honorable Supreme Court says, the defendant against whom injunction is sought is amenable to the personal jurisdiction of the court. Supposing, sir, there was no such clause 21. Then there is nothing that I can show that the defendant has agreed to submit to the jurisdiction of this court. And hence this court may have no jurisdiction over the defendant. But when our agreement specifically says that the defendant as well as the plaintiff will submit to the jurisdiction of this court for the settlement of their disputes, both the plaintiff and defendants become amenable to the jurisdiction of this honorable. Then 24B, if the injunction is declined, the ends of justice will be defeated and injustice will be perpetuated. And the principle of comity, respect for the court in which the commencement or continuance of action proceeding is sought to be restrained, must be borne in mind. In a case where more forums than one are available, the court, in exercise of its discretion to grant anti-suit injunction, will examine as to which is the appropriate forum convenience, having regard to the convenience of the parties, and may grant anti-suit injunction in regard to proceedings which are oppressive or vexatious, or in a forum non-convenience. Now, I may just elaborate on point number 2. Let me assume today we are faced with a situation that Paraguay in South America and Ahmedabad court, both courts have jurisdiction. Let me assume so. In that case, clause 2 will come into play. In case where more forums than one are available, the court, in exercise of its discretion to grant anti-suit injunction, will examine as to which is the appropriate forum. So appropriate forum under the agreement is Ahmedabad. Assuming both Paraguay and Ahmedabad has jurisdiction, the appropriate forum will be Ahmedabad because parties have agreed exclusively. I will take my lords to the judgments also of the Honorable Supreme Court from time to time, where it is stated that when parties use the word exclusive alone only in a contract, that supposing today Ahmedabad, Baroda, Bharuch, 3 courts have jurisdiction in a contract, and the parties say that no, but we decide that only Ahmedabad will have jurisdiction. Impliedly, Baroda and Bharuch are ousted. So even if anybody wants to go to Baroda or Bharuch court, they cannot go because parties have agreed to confer jurisdiction on Ahmedabad. I'll take my lords to those judgments. In a case where more, then clause 3, where jurisdiction of a court is invoked on the basis of jurisdiction clause in a contract, the recitals therein in regard to exclusive or non-exclusive jurisdiction of the court of choice of the parties are not determinative but a relevant factor, and when a question arises as to the nature of jurisdiction agreed to between the parties, the court has to decide the same on a true interpretation of the contract on the facts and the circumstances of each case. A court of natural jurisdiction will not normally grant anti-suit injunction against a defendant before it where parties have agreed to submit to the exclusive jurisdiction of a court, including a foreign court, a forum of their choice, in regard to the commencement or continuance of proceedings in the court of choice, save in an exceptional case for good and sufficient reason. Here the situation is reverse. Clause 4, Apnama reverse, where we have agreed with a view to prevent injustice in circumstances such as which permit a contracting party to be relieved of the burden of the contract, or since the date of the contract, the circumstances or subsequent events have made it impossible for the party seeking injunction to prosecute the case in the court of choice, because the essence of the jurisdiction of the court does not exist, or because of vis major or force major and the like, where parties have agreed under a non-exclusive jurisdiction clause to approach a neutral foreign forum and be governed by the law applicable to it. This will not apply to us, because there is no such clause in our agreement. I'm sorry. Then clause 6, a party to the contract containing jurisdiction clause cannot normally be prevented from approaching the court of choice of the parties, as it would amount to aiding breach of the contract. Yet when one of the parties to the jurisdiction clause approaches the court of choice in which exclusive or non-exclusive jurisdiction is created, the proceedings in that court cannot per se be treated as vexatious. So it's the other way around. If I had filed a suit here and they wanted an anti-suit injunction in Paraguay, let me assume so, then this clause will come into play. Clause 6. Now, these are the governing factors. 7, the burden of establishing that the forum of choice is a forum non-convenience or the proceedings therein are oppressive or vexatious would be on the party so contending to ever and prove the same. That will happen once the defendant comes here. The forum of choice, I read again, the burden of establishing that the forum of choice is a forum non-convenience. So forum of choice today between the parties is Ahmedabad. Now, unless if the defendant comes here and the defendant says that this forum is a forum non-convenience for XYZ reason, he may say my witnesses will be in Paraguay, I will have to call my witnesses here, my office is there. So forum non-convenience is a very common, if I may say, terminology used in international agreements and contracts, where though a court may have jurisdiction, the party can say that this is a forum non-convenience. It is not convenient to me or not convenient to proceed with the litigation in question, considering the witnesses, considering the subject matter, etc. But the defendant will then have to come here and then point that out, that despite having agreed to Ahmedabad, still Ahmedabad is a forum non-convenience. That can happen once the matter proceeds further. Today, now the question is, the next judgment, Rochelle, is 1987 1 SCC. If my lords can please have a look at the very bottom after the head note on the very first page. The appellant ONGC at the last 5-7 lines. The appellant ONGC entered into a drilling contract with respondent Western Company of USA. The contract provided for reference to arbitration in a case of any difference arising out of the contract. The arbitration proceedings were to be governed by the Indian Arbitration Act of 1940, read with the relevant rules. A dispute arose between the parties which was referred to 2 arbitrators and an umpire was also appointed. The arbitrators entered into the reference in London, which was the agreed venue under the contract, but they could not agree on the matters outstanding in the reference. Since the umpire remained present throughout the proceedings before the arbitrators, he made a non-speaking award, followed by a supplementary award without affording any hearing to the parties. The awards of the umpire was then filed in the Bombay High Court at the instance of the respondent. As my lords are aware, under the 1940 Act, the award had to be filed in the court and made a decree of the court. About a month thereafter, the respondent lodged a plaint in the US District Court, inter alia seeking an order confirming the award and a judgment for payment of interest until the date of judgment and costs, etc. by ONGC. The appellant on its part filed an arbitration petition under sections 30 and 33 of the Indian Arbitration Act for setting aside the award of the umpire and also prayed for an interim order restraining the respondent from proceeding further with the action instituted in the US court. The single judge of the High Court granted an ex parte interim restraint order, but by a subsequent order vacated the same after hearing the parties. The ONGC filed the present appeal by special leave against the single judge's order, vacating the ex parte interim restraint, allowing the appeal with direction set out at paragraph 22. Supreme Court held the appellant was entitled to the interim restraint order as prayed, as there was good and sufficient reasons for grant of the same. The High Court has undoubted jurisdiction in exercise of its inherent powers to grant such a restraint order whenever the circumstances of the case make it necessary or expedient to do so, or the ends of justice so require. It would be unfair to refuse a restraint order in a case like the present one, for the action in the foreign court would be oppressive in the facts and circumstances of the case. Though Supreme Court would sparingly exercise its jurisdiction to restrain a party from proceeding further with an action in a foreign court, the present case was one of those rare cases where the court would be failing in its duty if it hesitates in granting the restraint order. The respondent must be restrained from proceeding to enforce the awards in the US court because the awards may themselves be set aside by the Indian court, and in that event, an anomalous situation would be created in as much as the court in the USA would have enforced a non-existent award under which nothing could have been recovered. it would result in the valuable court time of the US court being invested in a non-issue. Both the sides would have to incur huge expenditure in connection with the attendant legal proceedings. Since under the contract, the parties were governed by the Indian Arbitration Act, and as such, the Indian courts had exclusive jurisdiction to determine the validity and enforceability of the awards. The American court had no jurisdiction in this behalf. The appellant invoked the jurisdiction of the New York court to pronounce on the same question, which was required to be pronounced upon by the Indian court. If the restraint order was not granted, serious prejudice would be occasioned, and a party violating the very arbitration clause on the basis of which the award had come into existence would have secured an order enforcing the order from a foreign court in violation of that very clause. There was a likelihood of conflicting decisions on the very vital issue, resulting in legal chaos. The enforceability of the awards must be determined in the context of the Indian law, as the arbitration proceedings were subject to the Indian law. If the Western company were permitted to pursue the matter in American court, the matter would be decided under a law other than the Indian law by the American court. So I would submit now in this background. Now, what would happen if the ad interim order is refused? Summons will go to Paraguay. I have not appeared there. The other side can appear and straight away apply for a decree. There is a positive statement made in my order 39 rule injunction application that after I was served with the summons on 8/10/25, I have not been served with any final order or anything further thereafter. So in my opinion, the suit is still pending as it is. But the moment, the apprehension is, the moment the summons of this court go, in absence of a restraint order, the plaintiff there can immediately apply for an ex parte decree by showing that, sir, in my suit in Ahmedabad, they have said that they have served and they have not appeared. I am applying for an ex parte order. It could be one in England, they call it there's a word for it. Default judgment, I'm sorry. In England, for example, I had the occasion to deal with it. They call it a default judgment. So the moment the plaintiff satisfies, I'm talking about the English court, that look here, sir, I have this defendant is based in Baroda. They are served. These are the papers satisfying the service, etc. So give me a default judgment. Default judgment is, it is a judgment which is based on the finality of procedure. So all procedure to serve the defendant is complete. Defendant is served. Defendant has not entered appearance. Give me a default judgment as if whatever is asked for is granted to the plaintiff. Another option with the plaintiff is, I will proceed now on merits and I will put in my witnesses, etc. There is no occasion for the defendant to come and counter check, nothing of the kind. So there is a default judgment or a judgment on merit. But either ways, that suit will be proceeded with further, because I don't intend to appear there. I am saying that this is the court which has jurisdiction. This is the court which has exclusive jurisdiction. Now, on the exclusive jurisdiction, Lordship, one judgment I'll just cite.
Thank you.
My Lordship, just give me a minute. It's my lords can have paras 40 to 56. It's a three judges judgment. Three judges have party to the judgment, and there is also concurring judgment of Justice Lopur. Head note C, paragraphs 40 to 56. But if my lords can please come to page 48. I'll take my lords to the judgment of Justice Lokur, which is a concurring view. Justice Lokur's judgment, concurring, leave granted. While I agree with the conclusions arrived at by my learned brother Lodha, Justice Lodha, this judgment has been penned down to raise the question: is it really necessary for this court to repeatedly affirm the legal position ad nauseam? I believe the law on the subject is well settled, and it is to nobody's advantage if the same law is affirmed many times over. The clause in the agreement that is sought to be interpreted reads as follows: the agreement shall be subject to jurisdiction of the courts at Kolkata. In my opinion, the very existence of the exclusion of jurisdiction clause in the agreement would be rendered meaningless where it is not given its natural and plain meaning. The use of the words like only, exclusively, alone, and so on are not necessary to convey the intention of the parties in an exclusion of jurisdiction clause of an agreement. Therefore, I agree with the conclusion that jurisdiction in the subject matter of the proceedings vested by agreement only in the courts of Calcutta. The facts of the case have been detailed by my learned brother, and it is not necessary to repeat them. Reference has been made to several decisions rendered by this court, and I propose to briefly advert to them. One set of decisions, then the other set of decisions is from para 42 onwards, which Justice Lokur follows. One page thereafter, towards the bottom, another set of decisions. My lords have got that? Para 42 onwards, ABC Levinats is referred, para 42. Yeah. Another set of decisions. In the second set of decisions, the exclusion clause is not specific or explicit in as much as the words like, only, alone, or exclusive, and so on have not been used. This has apparently presented some difficulty in appreciation. In ABC Laminat versus AP agencies, which is the most standard judgment on this issue, the relevant clause reads as follows: any dispute arising out of this sale shall be subject to KERA jurisdiction. Despite the aforesaid clause, proceedings were initiated by the respondent in ABC Laminat in Salem, Tamil Nadu. The appellant challenged the jurisdiction of the court at Salem to entertain the proceedings, since the parties had agreed that all disputes shall be subject to the jurisdiction of the courts in Kera, Gujarat. The trial court upheld the objection, but that was set aside in appeal by the Madras High Court, which held that the courts in Salem had the jurisdiction to entertain the proceedings. The civil appeal filed by the appellant in ABC Laminat case, challenging the decision of the Madras High Court, was dismissed by this court, thereby affirming the jurisdiction of the court in Salem court, thereby in Salem, notwithstanding the exclusion clause. While doing so, this court held that when a certain jurisdiction is specified in a contract, an intention to exclude all others from its operation may be inferred. The exclusion clause has to be properly construed, and the maxim expressio unicis est so and so, expression of one is the exclusion of another, may be applied. Looking then to the facts and circumstances of the case, this court held that the jurisdiction of the courts other than in Kera were not clearly, unambiguous, and explicitly excluded. Therefore, the court at Salem had jurisdiction. In RSD so and so, subject to Anand jurisdiction, 47, proceedings were initiated by the appellant so and so in ordinary original civil jurisdiction so and so. Respondent questioned the jurisdiction of the Bombay High Court in view of exclusion clause. Learned single judge held that the Bombay High Court had jurisdiction to entertain the proceedings. However, the division bench of the High Court took the view that the Bombay High Court had no jurisdiction in the matter and accordingly dismissed the proceedings in appeal. This court noted in para 9 of the report that the endorsement subject to had been made unilaterally by the respondent. Accordingly, there was no agreement. Then in Hanil era so and so, any legal proceeding arising out of the order shall be subject to the jurisdiction of the courts in Mumbai. On a dispute having arisen, proceedings were instituted by the respondent in so and so. This was objected to by the appellant, but neither the additional district judge nor Delhi High Court accepted the contention of the appellant that the courts in Delhi had no territorial jurisdiction in the matter. Appeal this court referred to ABC and after considering the facts, inferred that the jurisdiction of all other courts except the courts in Mumbai was excluded. This inference was drawn from the fact that the purchase order was placed by the appellant in Mumbai and was accepted by the respondent in Mumbai. Advance payment, etc., was made at Mumbai. And as per the clause itself, final payment was made at Mumbai in Balaji so and so. Then my lords can, I will go to paragraph conclusion 57 because various judgments have been referred to. For the reasons mentioned above, I agree with my learned brother that in the jurisdiction clause of an agreement, the absence of words like alone, only, exclusive or exclusive jurisdiction is neither decisive nor does it make any material difference in deciding the jurisdiction of the court. The very existence of a jurisdiction clause in an agreement makes the intention of the parties to the agreement quite clear, and it is not advisable to read such a clause in the agreement like a statute. In the present case, only the courts in Kolkata had jurisdiction to entertain the disputes between the parties. So the moment the parties have provided for jurisdiction of a particular court, let me assume in our agreement in clause 21, the word exclusively Ahmedabad, exclusive nothing lakhyu, khali Ahmedabad lakhyu. Then also the intention is clear that the parties want the disputes to be settled in the courts in Ahmedabad. The laws of India will be construed for the purpose of the agreement. Clause 21 can now be looked at for 1 minute, Lordship. That clause 21 in the list of documents, so that it can be more clear after we read the language of clause 21. At page 50 of that list of documents. My lords, sorry.
Yes.
Page 50, sir.
Yes.
Emma clause 21. This agreement shall be construed according to the laws of India. Now, if Paraguay suit is permitted to be continued, the agreement will still have to be referred to because he is also suing on the basis of this very agreement. So this agreement will now be construed according to the laws of India, but by Paraguay courts, if the injunction is not granted. 21.2. That is in the event of any dispute or difference between the parties relating to, touching or in connection with this agreement, both parties shall make an effort to resolve all disputes, differences or disagreements. Then 21.3. However, if any dispute or difference cannot be resolved by mutual discussion, the same will be finally, my lords, please note, finally and exclusively decided by the court of appropriate jurisdiction based in Ahmedabad. So there is a clear intention that any dispute under this agreement will have to be resolved in the courts finally and exclusively by the courts of Ahmedabad. So this exclusive jurisdiction clause is very, very apparent. Yes. Now, if my lords can now in this context. So if my lords can please have a look at page 134 of the list of documents. Page 134, sir, which is the last page of that plaint compilation of Paraguay suit.
Yes.
My lords of court, petition 7.1 to 7.4 can be ignored for the time being. 7.4 to serve notice of this complaint through a letter rogatory following the appropriate procedures, to issue a final judgment granting cost to the claims requested, and consequently 7.5.1 declare the nullity of clause 20.1, 20.2, so and so 21.1, 21.3, which I have been reading again and again, of the contract entered into between the parties dated so and clause so and so of the contractual addendum dated so and so, that is the amendment, declare that the unilateral termination of the distribution relationship in force between the parties since 2015 was carried out without just cause by Equilife, and therefore that the compensation requested under law so and so is due. Order that the company Equilife to pay to the sum of so and so, that is their currency, 32,172,384,870. I don't know how to Again. I know. મને પ્રોનાઉન્સ કરતા નથી તાની કરન્સી છે સાહેબ પણ એનું ઇક્વિવેલન્ટ છે I am told about 46 crores. Now in this background, my lords can please have a look at the impugned judgment. I may straight away go to the reasoning part. But before I go to the reasoning part, my lords can please have a look at page 13 of 18 of the impugned judgment. I think handwritten page is 32. Internal paging is 13 of 18. Para 17. So if my lords can just have a look at the previous page, para 16.
Yes.
Para 16, the learned judge refers to the first agreement, 23/12/2015. Then Vide, somewhere in the bottom, Vide pages 36 to 58. Manu sir, plaintiff has produced copy of the distribution agreement, that is the second agreement, 25/10/21, executed with clause 2.1, that is exclusive distributor. Then clause 21.1 is referred to, 21.3 on the next page is referred to, which provides that however if any dispute or difference cannot be resolved, etc. Then para 70, Vide page 64, the plaintiff has produced the amendment to the distribution agreement allegedly executed between the parties by which certain terms of second agreement were modified. What follows is important. Vide pages 95 to 156. The plaintiff has produced a copy of the plaint in civil proceedings 413 of 2024 instituted by the defendant before the court at Asuncion, Paraguay, along with summons issued by the said court dated 24/2/25, that is letter rogatory, whereby proceedings have been initiated against the plaintiff. Plaintiff has also relied upon the communications exchanged between the parties and their advocates. Then the two judgments are referred to. Then reasoning at page 34, para 20. Having heard the learned advocates for the plaintiff and having gone through the pleadings and documents on record at the outset, it is noted that the summons in respect of the foreign proceedings were served upon the plaintiff on 8/10/2025. However, the present application Exhibit 7 has been filed on 12/5/26. That is after a period of more than 7 months from the date of service of summons. The plaintiff has not been able to give any proper or satisfactory explanation for approaching this court after such delay in seeking urgent interim relief of the nature prayed for. This conduct of the plaintiff along with the delay in approaching the court shows that there is no real urgency and the bona fides of the relief sought. So that is delay, one aspect. Now I may pause here for a minute. One judgment of the Bombay High Court. I would submit, lordship, before my lords take the judgment on hand. Now, delay, lordship, is only one of the factors which the courts will take into consideration for the purpose of granting ad interim or an interim order of injunction. It is not that if somebody has come late. No, if you have come late, per se, તમને injunction આપવામાં આવશે જ નહીં. Court will, my respectful submission, court will look at the overall facts of the case. The court will have to see whether the plaintiff otherwise has a strong prima facie case, whether the balance of convenience is in favor of the plaintiff. Now, if by refusing the injunction on the grounds of delay, even at the ad interim stage, the loss that I am likely to suffer is, it has the potential to render my present suit infructuous. The moment the decree is made there, because the moment the summons go there, he will immediately apply for an ex parte order. So the idea is, where does the balance of convenience lie? I have, if I may say with respect, I have been able to show that I have a strong prima facie case. Now the question is of balance of convenience. Would the Honorable Court take the chance of serving simply the notice and rendering the present suit infructuous? Or maybe that injunction tomorrow can be vacated. But if it is not vacated, it has the potential to completely destroy my suit. So under such circumstances, if I have a otherwise prima facie strong case and a balance of convenience is in my favor, delay is only a factor. Court may put me to terms that if I do not let that the general apprehension that the courts have, ek baar injunction thai jase etle you will not conduct the application, you will not do this, etc., etc. I can always be put to terms under terms of order 39. But to render, it is potentially rendering me remediless in the event the decree is passed there. So the balance of convenience certainly lies in my favor. Now, in this context, my lord may have a look at para 110 of the Bombay judgment. Last but one page. Last but one page. The Bombay High Court judgment. Rajiv Sanghvi and Singh. Insofar as the submission on delay in filing of the suit and seeking interim relief is concerned, in my view, the delay by itself is no ground to deny the relief. In the facts of the present case, no prejudice has been caused to the defendants 1 and 2 by such alleged delay. There has been no attempt made by defendants to show any prejudice caused to them on account of the delay in filing of the present suit and seeking interim relief. There is much substance in the submission of Mr. Viraj Tulsapurkar that the question of delay, if at all, is required to be balanced against the likelihood of the plaintiffs ultimately succeeding in the action, and where the strength of the suit is prima facie strong, the plaintiff's delay, assuming there is delay in filing the action, would not disentitle the plaintiff to the relief. The Supreme Court in Dehri Rohtas has held that the principle on which the relief to the party on the grounds of laches or delay is denied is that the rights which have accrued to others by reason of the delay in filing the petition should not be allowed to be disturbed unless there is a reasonable explanation for delay. In my view, there has been no right which has accrued to the defendants by reason of alleged delay in filing the captioned suit and seeking interim relief. In fact, my lords may also take into consideration the suit in paragraph filed in November 2024. And I am served in October 2025, almost 1 year thereafter. And in my exhibit 7, I have made a statement. Yes. If my lords can please have a look at page 14 of that appeal compilation, of where my application is there in the application exhibit 7 in the before the learned trial court. I have made a positive statement in paragraph 27. My lords have got that? Immediately after the stay application, there is an exhibit list of documents with exhibit 7, below which the impute judgment is passed. In my page 14 per para 27 છે સર. હા?
Yes, sir.
મળ્યું કરશું. Para 27, the plaintiff states that after being served with the summons of the Paraguayan court on 8/10/25 of civil proceedings 413 of 24, the plaintiff has not been served with any summons and or order and or final judgment in respect of the state civil proceedings. The plaintiff therefore has reason to believe that post service of summons, civil proceedings before the Paraguayan court has not proceeded further, much less no final judgment has been passed therein. Now the apprehension is કે હું આ લઈને જાઉં ત્યાં ને એ લોકો ત્યાં decree pass કરી નાખે. Then I'll be the entire purpose is defeated. So where does the balance of convenience lie? To halt that proceedings for the time being and let these proceedings continue, or to permit that court to theoretically, at least on paper, imagine that let the decree be passed. Then what survives in the suit? Nothing. The balance of convenience therefore lies in restraining them from proceeding further, at least for the time being, till they come here and till they satisfy the court. Let me assume that they want to take the contention of forum non-convenience, etc., etc., etc. It is better to, prevention is better than cure, as they always say.
You are a Medicare company, therefore
બંને જણા છે સાહેબ.
you are distributor.
Huh?
Yes.
So now I may go back to that impute judgment. I was on the aspect of delay, which is a factor weighed with the learned trial court. I was on page 32, page 34, para 20 I just read. Then para 21. The plaintiff has stated that the defendant has filed civil proceedings 413 of 24 before the foreign court. The plaintiff has not produced complete and sufficient material before this court regarding the said suit 413 of 2024. My lords may see page 32, which I just read at the beginning, para 17, where the trial court itself records, with pages 95 to 156, plaintiff has produced a copy of the plaint of civil proceedings instituted by the so-and-so, along with summons, etc., whereby proceedings have been instituted. These two statements are completely inconsistent. Para 17, page 32 in the middle, para 17 in the fourth line. And I have produced what I have been served through the bailiff of this very court. The plaintiff has not produced the copy of the plaint and documentary evidence regarding the suit proceedings, which does not show the exact cause of action raised by the defendant before the foreign court and the exact reliefs claimed therein against the plaintiff. I just read the reliefs. I just read the reliefs in the Paraguayan court. Page 134, sir. I just read those reliefs. Further, so this is the second reason. Delay. Then the trial court says, I have not produced everything with regard to the Paraguayan court. The third reason. Further, the plaintiff has also not placed any sufficient material on record to establish that the court at Asuncion, Paraguay, has no jurisdiction to entertain the said proceedings. Now, this is again completely contrary to what the trial court records in page 16 on para 16. Completely inconsistent observations. I request my lords to please turn to page 31 once again for my satisfaction. Page 31, para 6, page 31, para 16 of the impugned judgment. At the very end, last two lines. The said agreement further contains clause 21.1, which provides that this agreement shall be construed according to the laws of India. Clause 21.3 further provides that, however, if any dispute or difference cannot be resolved by mutual discussion, same will be finally and exclusively decided by the court of appropriate jurisdiction based in Ahmedabad, India. Laws of India shall accordingly govern such proceedings. Now, my lords may please note, if I can again request my lords to please go back to paragraph 16, sir, only for reading one sentence. Paragraph 16, very first sentence. I have considered the rival submissions and gone through the record of the case. So this is coming as a part of reasoning, sir. Until para 15, the court records what is there in the plaint, my submissions, etc. Para 16 begins with the fact I have considered the rival submissions and gone through the record of the case. And having gone through the record, the learned trial court records for clause 21.1. And then in the impugned judgment, the trial court observes at page 34 now, para 21, page 34, last three lines. Further, the plaintiff has also not placed any sufficient material on record to establish that the court at Asuncion, Paraguay, has no jurisdiction to entertain the said proceedings. In absence of complete documents and sufficient material regarding the foreign proceedings, this court is not in a position to conclusively determine the jurisdictional issue at this stage. Therefore, in absence of such material, passing ex parte order against defendant restraining it from proceeding further with the case pending before the foreign court would not be proper or justified. The plaintiff has sought an ex parte ad interim injunction in terms of para 32B of the application seeking to restrain the defendant from continuing suit so and so before the courts at Asuncion, Paraguay, without issuing notice to the defendant. Grant of such relief would amount to restraining a party from prosecuting its case before a foreign court without affording any opportunity of hearing to the defendant at the interim stage itself. No, sir. An ex parte order obviously contemplates no hearing to the defendant. They have, if they had filed a caveat, they would have been heard. An ex parte order then becomes a bipartite interim order. After hearing the parties, the court may modify, court may vacate, court may confirm. But the concept of ex parte order is itself, it's an order which does not require a hearing. Such a course of action would be contrary to settled principles of natural justice as well as settled law, that anti-suit injunctions are extraordinary and discretionary reliefs to be granted sparingly and only in exceptional circumstances. There is no doubt about that. I am not saying it is mandatory, but I am saying I have come with a strong prima facie case and I have the balance of convenience in my favor. His very plaint is referring to these agreements. The very plaint in Paraguay says nullify clauses 21, clause 20, etc., etc. Now, if those clauses are nullified by one court, let me assume, sir, that if that court nullifies these clauses, how will I argue this suit here? Until the clauses get back to in the agreement. Both the parties are suing on the basis of the same agreement. One party wants the inconvenient clauses. જે એમને માફક નથી આવતા એ clauses તમે declare them to be nullity. ને હું અહીંયા એ જ clauses ના rely કરીને હું આ કોર્ટમાં મારો suit file લાવું છું. So if that suit is continued and that clauses get nullified, my suit becomes redundant. Let me assume, sir, let me assume that not even decree, but that court, let me assume theoretically, sir, that court stays the operation of these clauses. Let me assume so. Just as we are seeking some relief here, supposing that I'm just thinking, કે ત્યાંની કોર્ટમાં આ ડિફેન્ડન્ટ એ પ્લેન્ટિફ જે ત્યાં છે કે સાહેબ તમે આ ક્લોઝનું અત્યારના ઓપરેશન સ્ટે કરો. Then again my suit becomes redundant. So it is therefore, and I am relying upon the exclusive jurisdiction clause. And he wants that clause to be declared nullified so that I can never be able to approach this court. It is therefore, Lordship, that an ex parte order is very necessary in the facts of the present case. Then the Modi network has been considered, and ultimately the operative order at page 37, relief prayed by the plaintiff in paragraph 32B is hereby rejected. Issue urgent show cause notice, returnable 4/7/26. So that is how I am before my Lord's Lordship, that 32B in the facts of the present case is required to be granted, sir. It has the potential to destroy my suit and my rights under the agreement. The very clauses which protect me are sought to be nullified there. And this is the very purpose of an anti-suit injunction. And there are exclusive jurisdiction clauses, as I have pointed out. So I would submit, Lordship, that the relief which I have prayed here in the appeal, I have filed a separate stay application along with my appeal, which my lords will find immediately after the memorandum of appeal, paragraph 7, which is internal page 3 of the civil application, the application. 7B. And my lords can put me to terms. There is no doubt about it. If there is any apprehension in the mind of the Honorable Court, I can certainly be put to terms.
Yes, sir.
That is all, Lordship. I would humbly submit, Lordship, that in a case like this, the ad interim injunction was required to be granted, and there is an error by the trial court in not exercising the jurisdiction, Lordship. And there are, if I may say, inconsistent findings. On the one hand, the trial court says I have not produced. Before that, the trial court records that I have produced the plaint and everything. Clause 21 is referred to in the reasoning part. Then the trial court says that there is nothing on record to show exclusive jurisdiction.
What would be the stage at court at Paraguay?
The stage, we would not know, Lordship. Only positive statement that I have made is that after the service on 8/10/25, because એ સમન્સ અમને આ કોર્ટના થ્રુ જ આવ્યા છે. મેં તમને આપને બતાવ્યું ડિસ્ટ્રિક્ટ કોર્ટનો એના પછી અમને કઈ આગળ કઈ બચ્યું નથી. That is all that I can make a statement, which I have read from para 27 of my exhibit 7.
And for 6 months here, you did not bother to verify the stage also of your suit at Perigord.
But we have not done, sir. There is, we fear appearing there. Sir. And I'm told that there is a serious language barrier also over there. It's a Spanish territory.
But at least you know, verify for 6 months what would be the stage. Your apprehension with regard to the suit would be allowed.
Suit may be allowed, ex parte decree, or maybe an interim order. At least we are not served with anything right now.
On date, if we consider your submission, your apprehension also, that for 6 months, for we will find the other findings of the trial court, but for 6 months, maybe you have filed it later on, delay that as you argue. But then for 6 months, nothing has happened further even after service of summons.
Yes. We have said so. Sir, I may just point it, I put it a little differently.
6 months also in such a suit, you did not, you are not aware of what is the status of the suit. That's
So we can make a statement. We have not, the only way we can inquire is by appearing. Unless I appear, I cannot find out. So we have not appeared. So let me assume, sir, that some order has been passed. Let me assume so, but it is still not served upon me. My lords can just consider suit filed in November 24. Letter regulatory issued in February 2025. That comes to this court ફરતું અહીંયા ઓગસ્ટ સપ્ટેમ્બર 25 માં આવ્યું. 1 વર્ષ તો આ નોટિસ બચતા થયું, એટલે એના પછીનું શું સ્ટેજ છે, it may not have proceeded. We don't know at all. We don't know at all.
that would be a concern. Because you are not such a person who would be not reachable to at least know the status of that suit.
But my lords can let me assume, so if a stay was to be granted, the stay will become operational only from the day on which the injunction of this court is served on the Peregrine court or the defendant. So let me assume that some orders are passed. Let me assume against pass થઈ ગયા છે, પણ હજી they are in transit અને મને serve નથી થયા. So if that order is passed, already passed, it will continue, it will have its effect. But if it is not passed, assuming that it is not passed, let us assume both the possibilities, that something has happened thereafter. Some add interim order, final order, but that order is still in transit. If it is done, it is done. But if it is not done, at least I can be protected, sir.
That apprehension is without any force.
No, it is not, sir. Because once I was served in October 25.
You don't know what order has been passed subsequently or whether it is passed.
We are only saying we are not served with anything. That's a positive statement, para 27 of my exhibit 7. Para 27.
Because you neither inquire about the status of your suit at Perigord since you are served in October 25, nor you appear there when you come here.
Because this is a court with jurisdiction, sir.
You are right.
So because, sir, please imagine one thing, sir. If in any agreements of this kind where there are exclusive jurisdictions which are vested, the party which bypasses that clause, bypasses the court of exclusive jurisdiction and initiates a litigation somewhere else, what is the purpose? The whole purpose is Gujarati mein sahib kahe to mane dodto karo. Now, therefore, I don't want to go there. I don't want to go there. Even if it was Baroda, Bharuch and Ahmedabad, as I gave the illustration, Ahmedabad, Baroda, Bharuch, somebody, agreement is Ahmedabad, somebody does it in Bharuch. I don't want to go to Bharuch. I'll straight away challenge it. I did not go there to find out what is the status, શું થયું છે, summons બજા પછી state. No, I don't want to, because the exclusive jurisdiction is in Ahmedabad. Why should I go and start participating there? And if I inquire without appearing, it is all unofficial information, sir. From where do I get that information otherwise? I will rather play into their hands. The moment I appear and start participating, I will play into their hands. That is the very purpose that they want. Otherwise, these clauses will have absolutely no purpose in an agreement. And the clause 6 સાહેબ clause 6 એ તો હકીકત છે, કારણ કે એ લોકો જ કહે છે કે હવે આ clause ને તમે નલિફાય કરો, એટલે clause 6 તો હકીકત થઈ ગયું. જે ક્લોઝ સાથે હું અહીંયા રિલાય કરવા માંગુ છું એ જ ક્લોઝ ને એ લોકો ત્યાં નલિફાય કરવાની ડિક્રી માંગે છે. So the existence of the agreement, existence of the clauses is not a fact in dispute.
When did you send the amendment agreement?
Send, yes,
Or that is signed?
yes. Pages 61, 62, 63 of the paper trial court paper book, list of documents. Dated 2/11/23, 1/12/23 and 4/12/23 are the exchange of emails. And 1/12/23 is the amendment, signed amendment. કારણ કે અમે એમને પહેલા મોકલ્યું, એ લોકોએ સહી કરીને અમને મોકલ્યું, અમે સહી કરીને પાછું એમને મોકલ્યું. These are email exchanges. So 3 emails and the amendment itself is dated 1/12/23. અને એના પછી 2024 માં બધી ઘણી emails થઈ, negotiations થયા, અને નવેમ્બર 2024 માં એ લોકોએ ત્યાં suit file કર્યો.
This amendment agreement is not agreeable to them because by virtue of that exclusion.
Yes, yes. અને we have sent the draft. We sent the draft. The draft માં તો પેલું clause 2.1 માં exclusive શબ્દ કાઢી નાખ્યો છે. એ લોકો સહી કરીને અમને પાછો મોકલે છે. ને હવે કહે છે કે no, we have misled them into signing the agreement. I can understand it's a case of, let's say, forgery. It's not even their case that we have forged their signature. They said we misled them. તો તમે જોયા વગર સહી કરી? Those emails, my lord, will see page 61, 62, 63. Obliged, Lordship. I am grateful.
તારા બહુ ને શું નામ છે? તો જીતુભાઈ ને સહી જાણ કરી છે. જયંતિભાઈ ધીરુભાઈ કોણ? એટલે તારું જાણ કરી છે જીતુભાઈ ને, એ તારો ભાઈ થાય. પછી આ ભોલાભાઈ, તારે કોને જાણ કરી છે? નામ શું છે? અંજલિ. શક્તિ, તારા કોને સગાને જાણ કરી? સાગરભાઈ ને. તમને કયા ગુનામાં અટક કર્યા છે એ ખબર છે? નથી ખબર? ગુજસી ટોકમાં અટક કર્યા છે એવું કીધું પોલીસ? પછી કીધું તો તમારી સહી કરી હતી? અંગૂઠા કર્યા હતા? પોલીસે અંગૂઠા કરાવ્યા હતા? પોલીસે પકડ્યા પછી કઈક માર્યા હતા તમને? કોઈને નહીં? કોણ છે આયો? તમે શું નામ તમારું? ઇન્ચાર્જ? તમે ડીવાયએસપી છો? શું છે રિમાન્ડ માટે? કેટલા દિવસ? હા,
સિન્ડિકેટમાં ટોટલ 5 એક્યુઝ છે સાહેબ, એમાં 3 આપ નામદાર સાહેબ કોર્ટમાં હાજર છે. તો સાહેબ ટોટલ સિન્ડિકેટ ના 13 ગુના છે જેમાં થેફ્ટ ના ઘર ચોરીના બધા ઇસ્યુ છે સાહેબ 24 કલાકની હાજરીમાં સાહેબ પૂછ્યું પણ સીટીઆર કે ફોન નેટવર્ક નથી આપી શકે અને આ ચોરીના પૈસાથી સાહેબ કોઈ પ્રોપર્ટી લીધી છે
એ સીડીઆર ક્યાંથી આપી શકે એ લોકો? એ સીડીઆર ક્યાંથી આપે?
સીડીઆર ની સાહેબ ફોન આપે તો સાહેબ બીજા જે અત્યારે એક્સકોન્ડિંગ છે સાહેબ એની આપણે તપાસ કરી શકીએ એવી છે અને સાહેબ જે આ ચોરી જે કરેલી છે એના પૈસાથી કોઈ પ્રોપર્ટી પરચેઝ કરી છે નથી કરી બેંક અકાઉન્ટ ડિટેલ્સ સાહેબ છે અને જે આરોપી નંબર 5 જે એક્સકોન્ડિંગ છે સાહેબ એનાથી વેર અબાઉટ સાહેબ અત્યારના આરોપીઓને ખબર હોય એની અંદર ચાન્સ છે સાહેબ એની પૂછપરછ કરવા માટે 7 દિવસના રિમાન્ડ માંગ્યા છે
સિન્ડિકેટના કુલ ગુના કેટલા બતાવ્યા છે? 13 ગુના સિન્ડિકેટ તરીકેના છે. એટલે આયા છે નહીં, પૂછું છું સિરિયસલી જવાબ આપો. પાકું જ છે? મંજૂરી આપી છે તમને? ક્યાં છે મંજૂરી? So now why you want remand in this matter? Do not theft offences.
I quite understand
Why
said,
Gutsito in theft offences?
there are offenses like this in Saurashtra region by these 5 accused persons. Their age is also 25 to 26%.
So that,
Those are also like required to be recovered from the active person, so that we can find the absconding
but they are not such an offense who are involved can be.
Likewise, as per section 3 plus. Likewise.
But now, so no other left than Gutsito.
My hands are tied, but I only,
The act is very much tight.
I, but only for bank details and everything, because if a day's time can be given, by my loss, because we will be highly obliged.
So failure or to prevent the offense of theft, now Gutsito.
My
And now